9:01. I hereby call this, December 2025 Citrus County Code Compliance hearing to order. For these hearings, we follow an agenda, and the first item on the agenda is the call to order. The second item on the agenda is the pledge to the flag, so I'd like to ask you to join me as you're able for the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, the next item on the agenda is the minutes from Wednesday, November 19th, 2025 hearing. I have reviewed them. Are there any proposed modifications or changes, deletions, any objections to them as currently formulated? Hearing none, I'll go ahead and approve the minutes.
Staff update, we do have two appeals, Data Holdings, two different properties, same owners, different addresses.
We have two appeals?
Yes, sir. Fine appeals.
Oh, fine appeals. Okay. Well, we'll take them up in the order that you want. I don't really mind what the order is. All right, so I'm going to tell you all a little bit, give you a brief opening statement. My name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. Now, that's a fancy title created by law, but what it means is that Citrus County has hired me to preside over your hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I would ask that you please pay close attention. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present that case. You will then have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation, or your defense, as it were. I have to let the county to present its case first, because otherwise I don't really know what's going on, and I won't understand your defense. When you do have your chance, that'll be your opportunity to present evidence and make legal argument. It's important that you take your time during this process because it is likely going to be your only chance to make your case before me. I will also ask whether or not you are contesting that a violation exists. If you do not contest a violation, I will assume that a factual basis exists and ask you how much time you need to fix the violation and to work with the county. This will help save time for yourself and others, but you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of the parties, witnesses, or staff. Before issuing a ruling, I will also ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county has the right to foreclose on that lien or to seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. I'll also add that there are an increasing number of cases where the county's case is that you have committed some kind of irreparable harm and they will ask for a one-time fine. The same kind of circumstances apply and how that fine accrues and the time at which a foreclosure may occur. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs as well as the cost of the lien imposed. I may also continue the case if I find a need for further evidence or argument. And of course, you do have the right to appeal any order I make today as may be provided by law. Thank you.
First case is on today's agenda. Data Holdings, case number 2024-846 and 2024-780. Code Officer Alan Jonason, pages 15 and 16 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning. Okay, so are these the fine appeals?
Yes.
Okay, and so are both being presented at the same time? Actually, let's have appearances.
James Hartley with Gooding & Batzel, 1531 Southeast 36th Avenue, Ocala, Florida.
Good morning, Mr. Hartley.
Alan Jonason, Citrus County Code Compliance Officer.
Okay, great. So I think then, actually, if you don't mind, let me take a moment just to look at my notes on this that are in the agenda. Okay, so Mr. Hartley, what would you like to tell me?
So just to give the big picture of where we've come from and where we are now, this started as a code violation in November of last year. We were given 6 months for the installation of an improper or unpermitted gravel parking lot for a commercial parcel over the 2 parcels. So these 2 cases are related, so I do think we could handle them all at the same time. We were given 6 months to either obtain a site improvement plan or remove that lot. We'd gone through significant back and forth with the county leading up to a motion for an extension in May, which you did grant, giving us an additional 6 months, taking us to November. During that time, we've worked diligently to try and obtain this permit. However, we have not obtained it yet. We would have filed another motion for an extension prior to the expiration. However, there does appear to be some miscommunication between property owner, engineer, and myself as to who was keeping an eye on this deadline and who was supposed to be doing what at that time. There has been movement during this time.
As someone who practices in this area, I appreciate the code in which you're speaking. Let me ask this, though. Does the county oppose? I mean, are you seeking an extension or an appeal? I mean,
yeah, it was couched as an appeal. It's
Okay.
more of an appeal for leniency,
Okay.
not an appeal of any mistake that we're alleging.
what are you actually seeking then?
A 6-month extension.
So, Joanna Coutu, the Land Development, the last submittal we had, the last denial we did was September. That is my concern. I understand now there's a delay. That's good. I have spoken with his engineer several times to try to straighten it out. I'm just worried that September to December, there's been no action. So I don't want to kick this down the road and be here again.
Well, so Mr. Hartley, I guess here's my question. I granted the prior motion because there was a lot of evidence that y'all were working towards it. And of course, the point is compliance in Citrus County. So what kind of steps at this point, I mean, can you tell me what needs to be done?
Yeah, if I may have a binder with some of the
Yes,
evidence.
absolutely. Do you have a copy for?
I provided.
Okay, gotcha.
You want to look at it?
All right.
It was this morning prior to the hearing.
Okay, great. Well then, since you've prepared all this, I'll let you present what you want to present and tell me what you need.
All right, so we can just start with the exhibit list, and then, of course, it's supported by the exhibits that are listed there.
Let me ask this then. Ms. Harrison, do you have any objection to the proposed exhibits?
Given the nature of the hearing, the main objection is hearsay, but I understand that's admissible, and you could go to the weight.
Okay. Because what I like to do, if I can, is to avoid constantly having to admit is if you want to move the admission of all the exhibits,
I think that'd be efficient.
I do too. So what I'll do is I'll conditionally admit, and if there are any objections, I'll take up those objections, okay?
Very
All right.
well. Starting with Exhibit A, this is an exhibit that was admitted into the record at the last hearing. It was just to provide what was done between the initial code violation and the hearing on the last extension, to give you an idea of what was done. To summarize the majority of that activity, it was activity between the engineer and the county, as opposed to any of the other regulatory agencies that are involved in this.
Right.
The subject property is on a major highway, so we are involved with FDOT as well as Swift Mud. So the last hearing occurred in May. Exhibit B there is your order granting the motion for the extension. And then thereafter, starting with Exhibit C, is the drainage calculations that the engineer had to prepare in order to submit both, all to the county, FDOT, as well as Swift Mud.
And this is actually a document that was revised a few days ago.
Yeah, it was prepared in June after the hearing and then revised a few days ago based
Okay.
off of comments that we received from FDOT. So not to, waste a lot of paper, it's a 104-page report. I included the table of contents and narrative to give you an idea of what the contents of that document would be, but only provided 6 of the 104 pages for efficiency there. Moving on to Exhibits D, E, and F, those were submitted. Those are applications that were submitted on August 1st and the 4th to the county, Swift Mud, and FDOT in relation to the drainage connection, the environmental resource permit, as well as the site development application to the county. And going to Exhibits G, H, and I, in mid-August, late August, and early September, we did receive correspondence back related to those initial applications, all of which were requesting additional information. And then, as you can see in Exhibit J, on December, the engineer had prepared a response letter to FDOT related to those comments that they had given to us. And then finally, in Exhibit K, I've provided the complete site improvement plans that have been submitted to all of those agencies. So.
All right, if you don't mind, I'm just going to take a moment to look at Exhibits J and K. One moment. I'm not seeing anything that concerns me in terms of something that would take a year or more. I mean, it looks like from this letter that they believe, the engineer at least believes, that these things should be able to be addressed. So what's the step after? What are the next steps after this?
Responding to these comments, I do believe, based off of some of the county's comments, where variations from the code are going to be required, as well as there being multiple owners of this property, that a PUD may be in order. So we have...
I mean, that would dramatically change the timeline of...
Agreed.
We're talking about a PUD? I mean, does the county think that's a feasible solution to some of the issues?
Exhibit J is very telling to me. I had not seen any of those concerns, although I have spoken with the engineer. They are on a curve. There's a visibility concern with people slowing down and having to turn in. So I think a PUD is a very smart idea to just wrap it all up. We're talking, those plans haven't yet been submitted to the county, the Exhibit K, so they have it as of this morning. So get those in, but if a PUD's going to be needed, probably say a good 6 months now.
But then you have to factor in the Gooding and Batzel timeline. Could be another 3 months. I'm joking.
I mean, right now we're scheduling for March. A March hearing for the planning board, and then April for commission would be realistic if they turned it in today.
Does the county have an objection to the requested extension?
No, I'm glad to see Exhibit J.
Does that seem
helps
like
me.
reasonable? I mean, it looks reasonable to me based on the documents.
Right, it helps
Okay.
me. I did not know they were having those issues with FDOT. That's very helpful to know why it's been all pause.
Okay. Yeah.
One thing legally to address, since his timeline technically ran, I believe, at the end of November. I apologize, I don't have the date right in front of me.
November 26th-ish, yeah.
He's actually had a fine accruing for the last 20-ish days. So if you do grant the extension, we would request the special master make a determination as to whether or not that fine stands and stays.
It won't.
Or, okay, we just
It
need it
won't.
to be addressed. Thank you.
But I will say that there's got to be a motion for extension of time next time, you know? I mean, you know, it's one time grace, you know, and it's Christmas coming up, gosh knows. But, you know, the next time the feet will be held to the fire. So that's just a message to your client. All right, so I'll grant the extension. It's a 6-month. Now, what I'm going to do, though, is I'm going to extend it from the prior expiration date. Does that make sense?
It does.
I'm
I believe that would have
hoping.
been November 22nd.
Okay, it's from November 22nd.
Yeah, that would have been the prior expiration date. I
Okay.
believe the fine began to accrue on December 1st when the affidavit was submitted.
That would be right. So I will go ahead and reverse my prior order imposing fine, orders imposing fine on these cases.
So we'll issue a vacation order.
I'm going, yeah. Because I think that's a matter of public record, so
Yes.
I think we have to issue those. And issue a 6-month extension, but that, you know, it won't be extended again unless for good cause, and if the fine needs to accrue again, that's going to stay, even if there is an extension, okay? Any
you,
other
Your Honor.
questions?
No, thank you.
Thank you. Actually, I'm sorry. Is there anyone from the public who wants to be heard on either of these cases? All right, then, thank you. Yeah.
Cases. Next two cases, Timothy Robert Bevel, case numbers 2025-1977 and 2025-1978. Code Officer Erica Olson, page 5 and 6 of your agenda.
And Your Honor, while the parties are working their way to the podiums, I've been notified that both cases are no contest, that the parties have agreed to 90 days to cure on both of them and $50 a day fine thereafter if not cured.
Thank you. And just so everyone in the audience knows, part of the reason why we take the no contest first is because we don't have to stay for an hour-long hearing on each of these. And frankly, the arrangement that you come to with the county might be better than what you get from me, so it might be in your interest to do the deal. All right.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please state?
Chairman Bevel.
Leila Bevel. Thank you.
Okay.
Erica Olson, Citrus County Code Compliance Officer.
Okay. Are you Timothy?
Yes, sir.
All right, Mr. Bevel, did you hear the proposed resolution on both of these cases, namely that on each case, you'd have 90 days to abate the violation, and if it's not brought into compliance as ordered, there'd be a $50 a day fine?
Yes, sir.
Okay, and you agree to that?
Yes, sir.
Okay. Ms. Olson, is that your understanding of the?
Yes, sir.
Okay. And do you have any concerns that 90 days isn't enough time or anything like that?
There is a lot of stuff on the property.
On the scale, what is it?
Bad. Probably about a 9 out of 10.
Really?
Yes. Yes, sir. It's pretty bad. They initially asked for 30, and I said, "Do you
No.
sure you
Okay.
want 90?" And they said yes. So
Well, I am going to hold y'all to the 90 days then. I can't go further than that if it's that bad on the junk scale.
Right.
Is there anyone from the public who wants to be heard on either of these cases? I don't see anyone. So what I am going to do is I'm going to find that there is a violation in each case. I'll grant 90 days to abate the violation because y'all did come to this agreement in each case. And in each case, if it's not brought in compliance within the 90 days, there will be a $50 a day fine. Okay, then thank you for your time.
Thank you. You can just stay.
We're done?
No, you can stay for yours.
Okay.
Yes, ma'am.
Next two cases are no contest as well. Sarah P. Grogan, case numbers 2025-1975 and 2025-1976, pages 18 and 19 of your agenda. Code Officer Erica Olson.
Your Honor, the parties have discussed this case as well. Both cases are no contest. The parties agreed in 90 days to cure and $50 a day thereafter. Ms. Grogan, who was present for Mr. Belleville's case, is now her cases. I believe they're next door to each other.
Oh, okay, okay. So you're Miss Grogan?
No, that was my aunt. She deceased.
She's your aunt.
Yes, she passed away.
Are you an heir of the,
Yes, sir.
are you in possession of the property?
Yes.
Okay. Are you the only occupant of the property?
Yes.
Okay.
Of her property, yes.
Okay.
There is none on the other property right now.
County doesn't have any concerns with the, okay. All right, then you've heard the terms of the proposed resolution in each case. Was it accurate, 90 days in each case to bring it into compliance and then $50 a day if you don't? It is? Okay. Is there anyone from the public who wants to be heard on the Grogan cases? All right, I'm not seeing anything in response to that either.
You want us to put on the evidence, just in case?
I would like to see the pictures, just, I'm vaguely worried based on,
From just this one?
yeah, let's just look at this one for now, and,
These are just pictures. He's just gonna ask that you look over them and ask if you have any objections. Right?
part of it is I don't want to set anyone up for failure.
This is all the paperwork. Yep, yes, ma'am. These are pictures from, and this is the paperwork associated with that case.
Oh, yeah. Much of that's already gone.
Okay. Do you have any objections?
And that's just the stuff for her case, it's not for Mr. Belleville's case. Okay.
Okay, thank you. All right, I'm now looking at what's been proposed as Exhibits A and B in the Grogan cases, and I'm looking here. Okay, I admit them as evidence. I am going to uphold and grant 90 days to bring the property in compliance in each case, $50 a day if not brought in compliance. Okay? Thank you.
Thank you.
Good luck.
We done, sir?
Yes, ma'am.
Okay, thank you.
Next case, Cohen McKenzie, case number 2025-1904, 2025-1931. It's the one that's not contesting. Code Officer Erica Olson, page 14 of your agenda.
Your Honor, I've been
We'll do it
notified
after.
that the parties have discussed this case.
There's
And-
only one that y'all have been able to resolve?
Yes.
Yes.
Then I'm not going to take it
You're
up.
not going to take it?
No,
Okay.
we'll take it up when we'll stay for the regular hearing.
Yeah, this
Okay.
is the last one.
Okay? Oh, so you might want to just bring it up anyways, because one is, are there any other no contests?
That's the last no contest, so.
Oh, then
would
we
be
can take it up
rolling.
if y'all
Okay.
want. All right, I'm sorry, sir. Yeah,
Sorry, and we may be able to.
sort it out.
Resolve it right now.
I got you.
I don't think we had enough time to actually talk before we started. I'm sorry. Yep, sorry.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you
Yes, ma'am.
God?
Sean Lynn?
No, not Little John.
Okay.
Your Honor, I've been notified that they are the heirs. Ms. McKenzie, or Ms. Cohen has passed away, that they agreed to a no contest, 20 days to cure, and $50 a day thereafter if not brought into compliance.
Can you repeat that? I'm sorry.
20 days
Mm-hmm.
and $50 a day thereafter if not brought into compliance on the Cohen for 25/1931.
Okay. Okay. And what was the issue with the animals?
Too many.
Chicken?
There's too many.
And there's roosters.
And there's,
I'm sorry. I'm just not hearing it right. What?
there's chickens and roosters.
Chickens and roosters?
They're not allowed to have that many chickens, and they can't have roosters at all with a half-acre RUR.
Okay, all right. Well, that's too bad, because those are nice animals to have, except for roosters if you're a neighbor, so, I mean, let's face it. All right, and then, so the issue case is 25-1904, which I'd like to hear about from the county. I mean, what's going on?
So this case, sir, is the temporary occupancy of recreational vehicles, a violation of the Citrus County Land Development Code, Section 3140. When I went out there the first couple of times, they admitted to living in the RVs due to a roach infestation in the home and some renovations that they were trying to get done.
So there's a home on the property,
Yes, sir.
but they didn't want to live in it at the time.
Yes.
Okay. Then let's go through the case. I want you to present what you've got. I'll talk to them and we'll sort it out.
The address is 6817 West Jessica Court, Homosassa, Florida. This is 0.5 acres, zone RUR MH. Property owner is Elise M. Mackenzie Cohn. I have good service by posting on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 4th of March. My compliance inspection on the 18th. Oh my gosh, not March. I'm sorry. I apologize. My initial inspection on the 21st. My compliance inspection on November 12th.
The 21st of what?
October.
October?
Sorry. And my final inspection on December 15th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photos of the notice of hearing posted on the property, and a copy of the posting affidavit.
Okay, sirs, I'd like you to take a look at these documents and let me know if you have objection to them being evidence in this case. You have an objection, sir?
I object on Exhibit A 1-5.
What is the objection?
The objection is an image of a commercial vehicle, not an RV.
Well, okay, so let me be more clear. So that's a comment on the evidence. So what I'm looking for is like well, I want to hear anything you have to say about it that opposes or is related to a defense or saying, yeah, this is a commercial vehicle, not an RV. But what this is the time for is to say, well, I object to the county's proposed evidence because it's fake, or I don't want to give you, but like, are these fake photos? Are they inadmissible because of some other legal reason, as opposed to, yeah, this photo is true. I know this is an accurate photo. I just don't think it supports their case. Does that make sense?
Yes.
Yes, it's the latter. Right, so we'll get to that. I just want to know if you have objection as a basis for me to not even look at them.
Just Exhibit A 1-5 and 4-5 or 4/5.
Okay, all right, I'll take a look.
These are all valid.
Ms. Olson, you'll have to put them in order.
Sorry.
That's your
You want me
job.
to? I'll
That's
put
your
them in
job. Yep.
They were in order.
Sorry.
Fire policy amendments, sorry.
All right, you have to bring them over here so I can.
And are there members of the public who want to speak on this? Okay, I see one. All right. Okay, no problem. All right, let me take a look at these, and I will look and try and assess the objection. Okay, so Ms. Olson, first of all, let me ask you this. On Exhibit A, 1 out of 5, I guess?
Yes, sir.
Yeah. I do see what I think has been described as a commercial vehicle, but are you showing is that the RV or?
That is an RV. I thought that what they're saying is a commercial vehicle. I thought that was also something that was being lived in.
Okay, all right, well, I just, that's fine. So part of the county's case is that there's being a temporary occupancy of one or more of these vehicles?
Yes, sir.
Okay, so all right. I'm now looking through all the photos, and your other objection was to page
4 out of 5.
4. Yeah, that's what I thought. Okay, I mean, based on what the county is saying its case is, we'll see if it's true or not. We'll see if it's legal or not. I'm going to overrule the objection and admit exhibits A and B as evidence so that I can look at them. Please proceed.
Yes, sir. On October 21st, I conducted my initial inspection and observed multiple RVs, roosters, and approximately 15 chickens on the property. During this inspection, I made contact with a male subject who identified himself as Josh and who stated that he was the business partner of the owner's surviving son, Sean Lynn. Josh confirmed that the individuals were residing in multiple RVs on the property due to a roach infestation inside the residence. During this visit, Josh placed a phone call to Sean Lynn in my presence, and I spoke to Mr. Lynn by telephone and advised him of the applicable ordinances and the steps required to abate the violations. Josh and Mr. Lynn were both advised of the compliance requirements. On November 12th, 2025, I conducted a corrective action inspection and made contact with a female subject who stated that she would retrieve Josh. I observed her carrying groceries into one of the multiple RVs located on the property. Josh then made contact and advised that the occupants were living in the RVs due to numerous repairs needed inside the residence, and he further stated that his mother was unable to walk on the uneven flooring inside the home. Josh stated that he would remove the roosters and unauthorized chickens, and I again advised him of the applicable ordinances, and I issued notices of hearing. On December 5th, the property was posted for hearing, and on December 15th, I conducted my final inspection and observed that the property remained in violation.
All right, well, I think I understand what the county's case is. What would you all like to tell me?
So I think I'll start. I took over the house from my mother when she passed away, and it had an occupant in there, and they just totally trashed the house. Me and Josh are trying to be in business together. It's kind of a friend helping a friend kind of thing, where I'm not charging them anything to live in the house, but they're helping me fix the house. And I don't really have money for a construction company. So we did not know that we were originally in any violation with the infestation and the problems with the house if we stayed in the RV while we were fixing the house. We later found out after everything that we would need a permit to do so, but I don't know of any permit for roach infestation to be able to stay in the house. And the floor is minor, we could fix that while we're staying in it. But we just didn't realize what we were breaking until we come up to a violation. So if anything, we could handle this today, we just need a little bit more time.
Okay, sir?
Okay, my issue that I'm having.
Actually, if I could get you to speak into the microphone.
Sorry. The issue that I'm having is, okay, obviously, the RVs, now we've gotten rid of one went back to Jacksonville.
Which is mine.
One is now covered with an RV cover because it's no longer being used, and one's still sitting next to it. I own a company called 24/7 RV Inc. and as well, Trusted RV and Marine Services. So the RVs obviously are something that do need to be sold, so they're still going to continue to remain on the property. Now, my commercial vehicles, I mean, sometimes I do indeed stay in my commercial vehicle, just like I would at any truck stop or any in any parking lot, you know, during the course of work. Now, but it's not being used as an occupancy. You know, I'm not occupying the actual commercial vehicle just as much as any other trucker would.
Well, I need you to explain that to me. So you're saying that, yeah, I stay in it sometimes, but I don't occupy it. What is the difference?
The difference between an occupied dwelling would be a period of time.
Right.
So, you know, like maybe one night I might say, okay, all right, I'm not going in. I'm not dealing with my wife right now. Okay. Let me finish up my work here on the computer and be done with this and, you know, whatever, go to sleep, wake up, go to work again. But so I can understand where there could be some confusion there. The issue that I'm on to the next issue, the other violation of the chickens. My wife does suffer from autism. I do the absolute best I can to keep her animal thing under control.
Well, Mr. Santiago, I mean, I want to be clear,
Yeah.
that case is resolved. I'm going to announce the
Yeah.
resolution on the animals.
I understand that.
Yeah.
Now, I understand the 20, her trying.
So I'm not going to take up that
Yeah.
case, and I'm not going to hear testimony unless you want to undo the resolution. If you want to undo the agreement and the resolution, I'll reopen the case. I'll issue, whatever. We can go through the evidence. But my understanding is that the only case we're going to deal with on this is the temporary occupancy of a recreation vehicle.
All right.
And I'm doing this out of consideration for everyone else waiting here. So I'm not going to take up a case that you've resolved,
Okay.
unless you don't think there's a resolution.
Sorry, it was in my notes and I just.
No,
Okay.
that's fine. But I'm not going to take it up if there's a resolution.
Yeah.
Sir, we'll get to you, don't worry.
That's why I wanted to ask for, a little longer.
All right, actually, why don't you all step aside? I am going to allow the public to come up and speak. I'll give you a few minutes to sort it out. Sir, would you like to come up and tell me a little bit?
Thank you, Your Honor. My
Sir?
name's,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes, I do.
Please state your name.
My name's David Slinkard.
Thank you.
I'm a neighbor of the people here that are, I live 105 feet from where these chickens are. There's multiple chickens. They cockadoodle all day long. My wife is a monitor tech for Tampa General Hospital in Brooksville. She works 12-hour night shifts. She has to come home at 8:30 in the morning, try to get some sleep. We can't keep our windows open now that it's nice weather for these noises. I've had to move
And that's
her-
not just the rooster, it's the chickens.
chickens and
Yeah.
roosters. I had to move her from our bedroom, which is on the end of the home nearest them, to the other end of the house in a spare room so she can at least try to get some sleep. She has 50 monitors that she watches in ICU. Very technical job. She has to have her rest. And this noise from this farm animals is just, I'd like to play this for you if I could, sir.
Your Honor, we're not here on the chickens, and we can't take into evidence.
I want to
an
hear it
audio.
because I might reject the settlement. So I overrule a county objection. If you're going to play a sound, then I'm okay with listening to it. I hear some wind. There's the smoking gun.
That's one.
Yeah.
This is constant, all day long.
I get it. Yeah.
So, and they're saying they're renovating that house? They haven't done nothing to that house. They're not staying in the house. I walk by there in the evening, dark, nothing. They're in them campers. They've been in them for, be 2 months come next week. Our house, or our little street was a nice, quiet place to live. And then they showed up in them campers, and there isn't just him. There's at least 6 or 8 people that are there, plus kids that don't even go to school because they're there all day long, so how can they be in school? And it's just a nuisance to the neighborhood. I mean, it's a little private street. There's only 5 houses on it. my neighbor next to them actually started the complaining, had me get involved, and then somehow he give in to him. I don't know, from a threat or whatever, but now he's just silent. He won't even talk to me now. We're just fed up, Your Honor, or sir. It's a hard time for us. And my wife, you know, she can't get no sleep during the day. You can't have your windows open anymore. And now that it's been 2 months, when the wind blows from the west, you can actually smell an odor from that place, or someplace coming from that side of the property. And that's all I have to say, sir.
Thank you, Mr. Slinker. Is there anyone else from the public who wants to be heard on this case? All right. Mr. Shahid, are you okay? Okay. All right, let's bring up respondents. Would y'all like to come up? You either accept the settlement now or I reject it. You've got 3 seconds. 1, 2.
We'll accept it.
3. Okay. So let's put that on the record then. In case number 25-1931, the announced resolution is 20 days, because I'm not inclined to do it. I'm inclined to do 5, 6, 7. So if you want to accept the resolution, you can. It'll be 20 days to abate the violation here and $50 a day if not brought into compliance after 20 days.
Yes.
Okay. Then it's so ordered. And let's talk about the temporary occupancy of a wrecked vehicle case. You should have an opportunity to respond to what you just heard. Were you able to hear the public comment on this?
Yeah, I heard the public comment.
What do you have to say? I mean, you don't have to respond to it, but if you
I would
want
like to respond, especially in the courtroom, to somebody else. The people that just got out of the house were meth dealers. There's hookers and trash coming in and out of the house. I've actually got good people there, and we've been getting nothing but harassed since they moved in there. So there's no drugs there. There's no hookers. There's no unlawful, the stuff that we're going through right now is purely on accident. We did not know that we were breaking laws, and I know that doesn't constitute as not breaking the law, but we're really good people compared to what was there. So I don't understand why we're getting such a hard time. Now, for
the testimony, one thing I want you to respond to, because it's concerning to me, is the allegation
Yes.
of kids. So are there kids living there?
Nobody that's
my son is 17 years old. He is in homeschool.
Okay.
He works for me during the day and then homeschools during the night. That's what works
Okay.
for him, and that's
Okay. But there's no one younger than that?
no.
Okay. And Ms. Olson, have you observed any kids on the property?
I've observed a couple of children. They weren't small kids. They were as tall as I am, maybe taller, so I'm not really sure what their ages were.
Okay. All right. I mean, the reason why that is potentially concerning is this is I want you all to understand, there's this code section that, I'm reading it, and, let's see here. I want to make sure I find the temporary occupancy of a recreational vehicle on improved property, 2 weeks per address per year. Let me ask Ms. Harrison, I mean, do you think that, I think they've raised a defense. Well, look, these aren't all RVs. What's your position on that?
The Land Development Code defines recreational vehicle as a vehicular type structure designed for, and it lists a number of things, temporary living, recreational camping, and travel use. They've articulated that these vehicles are for travel use. They are sleeping in them. Therefore, they would fall under the definition under Chapter 1 in the definition section of recreational vehicle. We feel that it's broad enough to encompass any type of vehicle that the entity may be living in.
Where is that definition?
Page 37 is at the bottom
Page 37.
in Chapter 1.
Let's see. I don't have a page. Oh, I see it. Okay.
I'm sorry, Your Honor. Living in?
Oh, just give me a second. Thanks. I'm going to look up the definitions. On my version, it's 1-38, so I don't.
Apologize.
No, well, no, I mean, either. Okay, okay, okay. Is it the county's position that if someone has like a F-350, that they can't sleep in the vehicle if it's parked in the driveway more than 2 weeks per year? Or like, is there a code section that prohibits that?
The county's position is that it would fall under this provision as a vehicular type structure that is designed for travel use. So they can sleep in it for 2 weeks. So if they don't like their wife for 14 days out of the year, they can sleep in that in their front yard.
Ooh, I don't think so. Because otherwise there would be no distinction between recreational vehicles and almost any other type of vehicle. There has to be a meaning to recreational. Let me just take a look at these.
I'm sorry, could I just ask a question?
Yeah, sure.
Okay, so just like any other semi-commercial vehicle, like a semi-truck. Okay, so because mine is considered a straight truck.
Right, so
for
if
my
you're sleeping in a truck, I mean, as a lot of truckers do,
Yeah,
it's not a recreational vehicle.
yeah.
There's no way you can see that as a
It would
recreational
have to have
vehicle.
120 volt electricity, plumbing. I mean, I literally convert buses into RVs for a living.
But at the same time,
But through the DMV, I would have to.
clearly, you know, the whole point of this code section is to prevent what's happening in these vehicles. That is the entire point of this is, you know, there's no specific utilities hooked up to these vehicles. And, you know, if the house is uninhabitable, I mean, and it is, I mean, in this case, it is more like an RV than a regular truck. I mean, what I'm seeing in the photos in that, like, what's inside there?
Okay, so I have toolboxes, a television, computers, things that are all necessary for when we do jobs, like in Fort Myers or Oxford, Pennsylvania, things like that. I do service multiple areas in multiple states.
It does have sleeping arrangements inside of it?
It does have a couch, yes. You could sleep on the couch if you needed to.
Yeah, I mean, listen, I'm based on the way the code's written, I'm inclined to probably, frankly, find that there is a violation. You got to stay in the house. I mean, that's what the house.
And this is not a permanent situation. Nothing in life
Obviously.
is permanent. Everything's temporary.
Yeah.
You know, and as Mr. Lynn stated, you know, we didn't know we were really in any violations. We're trying our best to, you know, obviously as well contribute to this community by not having a home filled with drug addicts and, you know, sex workers.
Well, this isn't for me, it's not a moral case. You and witnesses, they're allowed to state their moral case and to make it about that. But to me, it's not about good or bad people. It's about whether, because I can't judge that from here, frankly, but it's about the code, and this is not a tenable situation under the code. In any similar situation, you get 2 weeks inside the vehicle when you have a house on the property, because otherwise that's the point of the house. So
if I had a permit to work on the house, how long would you be allowed to stay in the RV?
What is the county's position on that?
Well, generally, we could allow that for a house construction. For a code case where they've already been cited, we would not allow an RV while they have an active permit, especially for a mobile home. It should not take the time that a house would. So we have a temporary provision when you have when you have a permit to allow you to live in an RV.
While you construct a new residence?
While you construct a residence, yes.
What about renovation of a residence?
Depends on how detailed the renovation is. If it's to install a window, absolutely not. If it's, a fire and half of it's gone, yes. But our commissioners have been really clear that if it's a code violation case about staying in the RV, they've lost that ability to get that grant.
Okay. Look, the concerns I've heard are real concerns about the house in that I wouldn't necessarily want to stay with a cockroach infestation. Although they happen. This is the state of Florida, so good luck finding a place that can. The other thing, the floor, I'm having a hard time seeing it. Really what I'm gonna do is I'm just gonna tell you what I'm gonna do. I'm gonna find that there is a violation. I'm gonna give you a time to comply. Okay, how much time? How much time do you need to comply? Like, stop occupying these RVs and staying in the house.
So we had an exterminator come out that was supposed to fix this issue. And then we tried to attempt it ourselves as well after we paid an exterminator to fix the issue. Now there's still roaches in there. They're not as bad as they were in the beginning, but from what I'm told is they didn't move in overnight. They're not going to move out overnight. Obviously due to health concerns. I cannot put my mother, who already has health issues, into a home where there's going to be a possible cockroach feces into a contamination situation. Also, that would be, I could not do it. So I'm requesting 60 days. Just flooring, because I believe in order to actually exterminate this property properly, walls are going to have to come down. So we're going to have to apply for a permit to remove drywall and actually exterminate this properly, because every other attempt has failed.
This case has been pending since October, so you've already had 2 months. You've already had 60 days.
I do. I understand that.
Okay.
And during that 60 days, we
So I'm not doing
utilized every
60
bit of time.
days. I do understand the position. The problem is the code, and honestly, I'm not sure that I'm not sure your health concerns are that much better with your current situation. The cockroaches are there. They're on the property.
I feel like we're almost there as far as getting it. We just got a few more steps to take, and then we're able to move.
Yeah,
everybody
guys, I
completely
can't, what I'm gonna do is I'm gonna run this with the other case. I'm gonna grant 20 days to bring it into compliance, the situation into compliance, and that gets you past Christmas. And if it's not brought into compliance as ordered, $50 a day.
Thank you.
I would also like to go on record.
Make your record.
I am very glad that we live in America and we have the opportunity to face our accuser, and our accuser decided to show up. So I would also like to let him know that I will be serving him with an intent to sue for deprivation of character and stalking and harassment.
Okay, thank you all.
Thank you.
Thank you.
Sir, you made your public comment. I took it into consideration. The hearing's now over. Thank you.
Next case on the day's agenda, Victor Shahid, case number 2025-1785. Code Officer Julie Wilkinson, page 32 of your agenda.
Mr. Shahid, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Victor Shahid.
Thank you, sir.
Good morning, Mr. Shahid.
Good morning, sir.
Morning.
Good morning.
So this case is a case for accumulation of vegetation. He's got just a quick rundown if you're still interested in that section, but he's got a pool deck that is completely covered with leaves, and an in-ground pool that's the whole entire bottom of it is filled with leaves and has like 10-foot trees growing out of it. And then outside of the pool deck, he's got piles of tree debris.
Mr. Shahid, do you disagree with that?
Yes, I disagree because everything have been cleaned out. My lawyer and 3 of them, they come in, they said what they want, and I have somebody that take the wood out, take a garbage out, and haul it to the landfill.
So as far as you're concerned, the property is clean today?
Yes, it is.
Okay. Ms. Wilkinson, I mean, is this a repeat case?
Your Honor, for the record to clarify, Mr. Shahid has a co-occurring citation case for junk and debris.
A co-occurring?
Yes,
There's another
they're
case.
running at the same time. This case is with Your Honor, and then the citation case is running in front of Judge Spate. He does have an attorney in that matter. We all did go out and discuss, as he's just talking about, the stuff for the junk and debris case. This case is separate from that and is not involved with
Mr.
that
Shahid,
matter.
does that make sense? You have 2 cases going right now. One is in front of a real judge, and then one is here. And this is the accumulation of vegetative matter case.
These have been cleaned.
Okay. Ms. Wilkinson, go ahead and present your case, and because let's get on the same page.
Yes, sir. Case number 2501785, excessive growth and accumulation of vegetation in violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 9351 North Citrus Springs Boulevard in Citrus Springs. Property owner is Victor Shahid. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 30th and October 17th, 2025. Photos from a corrective action inspection on November 5th, 2025, and photos from my final inspection conducted on December 16th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Sir, I'd like to ask you to take a look at these documents and let me know if you have objections to them being evidence.
All the vegetation have been removed.
Okay, so I mean, I still need to see this stuff. If you're saying it's gone, whatever the
It's
issue is, it's gone,
gone.
then we'll talk about it.
Yeah.
But let me take a look then. All right, exhibits A and B will be admitted as evidence. I'll just take a look at them right now so I understand. Okay, so Ms. Wilkinson, I see a bunch of different things here that I'm wondering. So like take, for example, page 1. Is there anything you want me to see on page 1?
No, that's just showing the front of
Okay,
his house.
all right, so it's setting the scene. And then page 2, you've got dead leaves on a porch. Is that,
That's inside the pool cage.
Okay, but you, and so the dead leaves are, in your mind, a violation?
Yes, in my mind, it is an
Okay.
accumulation of vegetation. It's creating a nuisance with mosquitoes for the neighbors.
All right, and so then I see page 3, and then page 4 is where I can see the pool.
But
I
there's
do,
no-
I do.
There's no pool in there. A pool
No, you're right, it's not a pool, it's a
drained and
it's
nothing
a
there, no
huge
pump.
crater in the backyard. It's a huge crater in the backyard.
Yes,
Yeah, and it's got, in the pictures from October, I can see growth that did come through, and that's fine. So I'm moving through the photos, I'm moving through November, I'm now in December of, well, yesterday. I see some branches, I see some blurry photos, okay. So you're saying that that's all gone from the crater?
all gone, everything went to a landfill. And
When did it go?
last week, and I have one trailer was left this week. And like I said, a lawyer take a picture for what the county want and relay a message to that man, he taking care of it. And he did everything she want, got done.
It's so I'm just, so the photo taken yesterday, and I don't, this is a photo taken yesterday, and it purports to show some, I guess, saplings, kind of trees growing through your crater floor. So, I mean, is that what the county's case is?
Yes.
Okay. So to the best of your knowledge, that's still there, correct?
That big tree is still there.
Do you intend on keeping it?
Yes,
Okay. So you're no longer going to use...
because you cannot burn it, no burn time. And it take time to take it to the landfill, and it's already big tree. It's not a small one.
All right, we're going to have to dive into the code on this. Let's look at 20-61. Because so Ms. Wilkinson, the way I'm looking at it, so you know, and the county attorney knows, is it appears to me that you have 2 sets of violations. Maybe you think there's more, so I want to understand the county's case. I see the dead leaves in the structure, you know. It appears the roof is kind of partially gone and it's decayed. But also the growth inside the crater, the concrete crater. Are those 2 the alleged violations?
Yes, and the bottom of the crater has a thick layer of leaves in it as well.
Okay. All right, so let's take a
And,
look.
and there's also like piles of tree debris outside of the pool enclosure.
All right, so 20-61. It shall be unlawful for any person owning, leasing, occupying, or having control of any property subject to the provisions of this section to permit or maintain grass, weeds, brush, and undergrowth in excess of 18 inches in height or an accumulation of vegetative matter. And okay, and I am going to turn to the definitions here. Vegetative matter shall mean grass clippings, plant clippings, tree limbs, fallen trees, palm fronds, piles of leaves, and other yard debris. The thing I'm having a real hard time with is dead leaves being a violation of the code section, because if it is, then you have thousands upon thousands of people in Citrus County who are in violation of your code. I have never seen a code case brought for dead leaves.
Your Honor, at this point, it's not just that there's dead leaves, it's the accumulation. At this point, his pile has become his entire back lanai, his entire, what are we referring to the pool as? The crater, sorry.
The concrete crater.
His pile isn't just, most people accumulate their vegetative matter in a pile, they rake it together. And if that's there too long, it would constitute as.
Based on the code section, I
Correct.
agree with that.
And we've had other cases such as that.
Yeah. But he has not. There is no
His case
pile.
has reached the point where his pile is his entire back lanai and his entire crater.
But
It's all accumulated there, and it's now reached the piles.
I think how you worded that is exactly right, Ms. Harrison. And normally, the word pile has to have meaning.
Correct.
There is no pile here. There is a layer of dead leaves that have not been raked, have not been accumulated. They're just lying there like a lot of owners do, and it's biodegradable.
Not in your crater and not on your pool
That's
deck.
true, not in the concrete crater.
So the leaves, as Ms. Wilkinson has articulated, is only those in the pool deck and in the crater. She's not articulated the leaves outside of the pool deck and the crater have become a pile of vegetative matter. She's articulated that I believe there is a limbs that have been cut and those that are accumulating outside of the pool screen enclosure.
I'll take up the limbs separately. I do
Okay.
see the limbs, but I really struggle to, if you have a layer of dead leaves, even in a functioning pool, I don't think that's a violation of the code.
It hasn't accumulated to the point of a pile.
I don't think this has either. I see your point. I can't imagine. It's just a layer. Whether it's a real pool or a concrete or it's on a roof and it hasn't been removed from the roof and a roof is completely covered with dead leaves, that cannot be a violation of the code. So I can't do that. I can't hold that against all the people of Citrus County. So I won't find that the concrete crater part is a violation. Now, in terms of the porch, I actually think that is slightly different. And in looking at it, by the way, I'm not saying there aren't other code sections that might apply there. And looking at the porch, Mr. Shahid, is this property occupied?
No.
No. What's happened to the porch? What's happened to the porch? It looks like the roof isn't really there anymore.
It's no pool, no cover for a pool, even a room where a pool in is already up to the air, nothing holding it.
Hold on, let me just think about this. I'm looking at the definition of vegetative matter. Okay, now I'm going back to 20-61, or 20 dash. What's the county's position on the stuff growing out of the concrete crater? What is that? Trees?
Yeah, they're trees.
What kind of trees?
I don't know.
Okay.
They're
We've been through
taller
this.
than
We had
I am.
another case where we looked at the definitions of these things, I think brush and undergrowth, and we saw that it includes saplings, it includes things like that. I don't know how long they've been growing, to be honest. Do you?
I don't know.
Isn't this just like when someone puts in a sidewalk and something grows up underneath it and it goes back to the land over time, the concrete goes away, and why can't he have trees growing out of the concrete crater? By the way, I'm
Well,
not contesting it looks terrible. I know it looks terrible.
So
I
mean, the reason why this complaint came about is because of a neighbor, and they have children, and they are inundated with mosquitoes. And I have no doubt that this accumulation of vegetation is contributing to the abundance of mosquitoes over in that area. With the leaves being on the pool deck and in the pool, there
That's a
is no
habitat.
drainage for water. It's just sitting there and accumulating and creating a habitat for these mosquitoes.
So it's a nuisance.
Yes.
I agree it's a nuisance. And these code sections are supposed to be about addressing nuisances.
Your Honor, at this point, the county's argument would be that the crater was intended as a pool. Its function is as a pool, not to grow anything in excess of 18 inches. And the items growing in there, whether, because we don't know what they are in excess of 18 inches, and they should not be growing where they're not intended to be grown. They would qualify as a weed then, and therefore they should not be there.
Mr. Shahid, do you want the growth coming out of the concrete crater?
To me, it doesn't matter because it's not bothering anybody. The leaves have been cleaned, the trees have been cut. The neighbor himself, which complained, come to help cutting and rest a tree, and everything was running okay.
But I think there is a violation of the pool screen code, but that's not going to fix the...
But there's no pool.
Well, actually it would, because if there are leaves in the pool and leaves in the porch, and they're cited for a violation of the pool screen code, and he has to fix the pool screen, then the mosquitoes don't get out or in.
Well, the pool screen, he has a fence around the backyard, so the pool, it's my understanding there's not a pool violation for the screen, and the screen is the top part that's broken, so as, yeah, yes.
Okay. Sorry, this is the first time a case like this has been brought, and I'm going to think about it. I'm not saying I'm continuing the case, but I'm going to think about it and take up other cases while I think about it. Okay?
Thank you.
Thanks.
Next case, Maribel Rosa and Jesus Sepulveda.
Actually, I was notified that we've had a no contest happen while it's waiting. If Your Honor would be inclined to do the no
I
contest.
am. I'd like to get them out. I do want to talk to y'all, so it might take a little time.
It's GSMS 2015 GSI South Suncoast Boulevard, LLC 25384.
Page 20 of my agenda.
Yes. And I was told Ms. Ramirez, the property manager, is present.
Okay, great.
Parties notified me that there is a no contest on this case, 14 days to cure, and $50 a day thereafter if not brought into compliance.
Could we do a swear-in?
Do you swear to tell the truth, the whole truth, and nothing but the truth so help you God? I do. Please state your name. Kelly Ramirez.
Good morning, Ms. Ramirez. So you heard the terms, 14 days. If it's not brought in compliance, $50 a day?
Correct.
Does that sound right?
That's correct.
Is there anyone from the public who is here to speak on this case? All right, then I'll go ahead and ratify it. I'll find that there's a violation, but grant 14 days to bring the property in compliance. If it's not brought in compliance, $50 a day.
Okay.
That's it.
Thank you.
Thank you.
Just let me know. Otherwise, I'll be out there.
Okay.
All right. Sorry, JC.
No, that's okay.
Now let's take up the other case.
All right, next case, Maribel Rosa and Jesus Sepulveda, case number 2025-1522, Code Officer Erica Olson, page 31 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, sir. Please state your names. Maribel Rosa.
Jesus Sepulveda.
All right, welcome back. So thank you, by the way, for providing me a brief. Thank you for providing me a brief. Did you get to read each other's briefs?
We did.
Okay. The only factual issue I'm having is what the property appraiser's classification of the property is. Can you show it to them? Because I don't know the answer to this. Can you all look at the document and let me know if you have any objection to this being evidence? I don't know if this is going to resolve my question or not, but we'll get into that.
Yeah, it's so it's like rural residential.
That's
like
zoning.
It's just saying ag now.
Oh, okay. Yeah. Okay.
Do you have any objection to this document being
No,
evidence?
it's
Okay.
It's,
I think I've seen it, but let's see. Oh, I see. Okay. So let me ask the county some questions about this. Where did you get it?
The property appraiser's website.
Okay. And where on the property appraiser website is it?
It's the property card.
Now, in the, I'm just looking at some information on this. Look, there is a part of the property appraiser card. I mean, do you mind if we take judicial notice of the property appraiser card?
No.
Okay. Quote unquote judicial notice. I'm not a real judge, as you know. But I think that there is a portion of the card that says property type A or something like that. And I want us to talk about it, so I'm going to pull it up here as well.
And they've changed and added 2026, so you have to make sure to go back to 2025.
Wait, why?
Because we're in 2025, that's the year that this is in contest. I mean, it still says the same information for 26, but this violation occurred in the proper year of 2025.
Well, yeah,
for
but
consistency's sake.
if they were going to get the classification a week from now, I'm not going to find that there's a violation.
Well, 26 has a no as well for ag class.
Okay, but
so.
that's what I'm trying to figure out. So, but when I look at the website, and I want to, for some reason, I can't quite pull it up. Oh, here we go. If the property appraiser's office is watching, this is not the easiest property appraiser website to use. And I think you should spend some of your budget on that. Let's see. Okay, so I've got the property card up, and there is a part, 4.54 acres, sound about right? Okay, that's what the property appraiser says. And if I scroll down, so down at the land and agricultural section, it says mobile home, non-waterfront, type A acreage. Type.
You're referring to the T?
Yes, or no, I don't know. I'm scrolling, I'm looking up the page. It might not be the card. I'm looking at on the website on the property appraiser for the property.
Oh, okay. So, and if you go to the right where it says type acreage and it says classified value and ag flag, if it was flagged as agricultural, it would be noted there.
I don't see where you're looking.
May I approach you as well as the Sepulvedas? One moment, I'll come around.
Yeah. If y'all want to come up to see what she's showing me, that might be a good idea because I want us to be all on the same page. That's where I'm looking at, is the type.
And then it would say agricultural flag and classification, it would be.
But why does it say in type A?
It says that on everyone.
Acreage,
Yes,
it's actual acreage. Like
Just A for acreage?
yeah. On
Okay.
every parcel, it would say A dash
So if I
acreage.
looked up any other property that comes before me today, it'll say A.
It should. There might be some that are like apartments, and they might be a little
Okay.
different, but
All right, that was my real confusion. Does the county's position make sense? Are y'all applying to get the agricultural classification?
Once it makes sense for us to apply for it, then we will, because like I said, we don't have receipts or sales or any sort of, evidence that we're, a producing business.
I looked at the criteria for the classification, and there's not one specific factor that the property appraiser uses in coming to the, in other words, I think sales is a factor, but it had something like 10 or 12 factors.
It's a lot. They might want to consult an attorney about.
Yeah, I can't get legal advice,
But-
you're right, but
I went to the actual place and I talked with them because everyone was sending me back and forth to different people, and it was just a big triangle of charades. But they told me that one of the main things is I have to show that there's receipts.
it's so strange to me because that sounds like it's a
And
chicken and the egg thing. Like,
Yeah.
how do I ever do this in the first place? I guess you'd have to buy property that starts out as agricultural as their position. It doesn't make a lot of sense.
Unfortunately, the way I've read the statute is intended to protect already existing agriculture, and it's created this very murky area of if you're
Someone who
trying to
wants to just-
start, you almost have to comply with all of these things to get there, and then once you get there, you don't have to comply with them anymore. I didn't write the law, but that seems to be what I've found in my research.
That is how special interests work. They buy laws that will protect them. Guys, I can't get around the part of the statute that does say that it has to be classified like what you just saw, and it's not. So I am going to find that there's a violation, and you're not exempted.
Can I say a rebuttal?
Put whatever you need on the record. You have the right to appeal.
Okay. The statutory protections under Florida's Right to Farm Act protect agricultural operations, not zoning labels. If zoning controlled agricultural activity, aquaculture operations would not legally exist in residential areas. Yet the state of Florida routinely certifies and regulates aquaculture facilities, including systems located on residential property. Aquaculture is defined as agriculture under Florida law. Because of that, aquaculture operations are protected agricultural uses and aren't restricted by zoning. The county is arguing that my property must be classified as agricultural, but that requirement does not exist in state statute. At the prior hearing, Code Compliance Officer Erica stated that if a site improvement plan had been issued, this case would not exist. That acknowledgement directly conflicts with the county's current enforcement position. Under Florida statute, regulatory authority over aquaculture rests with the state, not the county. For those reasons, I request dismissal of the violations and recognition of the applicable agricultural exemptions.
So here's the problem. Most of what you're saying is correct, but there's one key flaw. You're right. It doesn't matter specifically what the zoning is, but you do have to have an agricultural classification from the property appraiser, and that's not a zoning determination. It's not a zoning determination at all. So that's why close examination of the county's brief is required. And the key is that in order, either under the Right to Farm Act or other applicable sections, it not only has to be a bona fide operation, farm operation, it does have to be classified as ag land, not zoned as ag land, classified. What's the county's recommendation?
The county recommends $100 a day after the date that you deem sufficient, plus administrative costs.
Let's assume that you don't appeal. What I'm trying to ask is, how much time do you need to bring the property into compliance, assuming you follow the order?
All that was needed for to bring the property to a compliance was a site improvement plan, a basic procedural protocol piece of paper.
There's several things that you could do to bring the property into compliance. For example, you could stop doing what you're doing. Would a site improvement plan abate the violation?
It will, but it's not like a hand-drawn drawing. This is for fill. That is an engineering type thing. So if the fill is going to stay, they will have to have engineered drawings compensating for the stormwater, depending on how much fill that has been placed.
Well, so you're not requesting a one-time fine?
No, this can be fixed with engineering to make sure stormwater is addressed, and it sounds like you might have already addressed it, but I don't know.
But with the site improvement plan, engineering would be required.
Usually for fill, that is true, yes.
Engineering on fill.
Because of stormwater, yeah. There are some de minimis ones, so depending on how much fill is there, engineering will work with him, our engineering section. He might qualify for de minimis. That is something that usually homeowners can do.
This is a agricultural, it is part of the agricultural project, and the filter is a necessary, like.
No one's arguing that. What they're saying is that in order to receive county approval when you submit for the site improvement plan, either it's going to be de minimis, in which case, okay, you won't have to do as much, or it does require some kind of engineering to corroborate the fill.
The problem that I have is that the regulatory authority just goes to FDASC, the Florida Department of Agriculture and Consumer Services. I listed the statutes, Florida statutes, that directly.
All right, I've explained to you why you're wrong twice. I encourage you to retain legal counsel. I'll grant you 90 days to bring the property into compliance. I can't get an answer as to how much time you need, so I'll give 90 days, and it'll be $100 a day if not brought into compliance.
How do you get into compliance?
And I will issue a written order.
Okay.
Thank you.
Thank you.
Not yet. I'm not trying to keep you, Mr. Shahid, although I always enjoy when you come. I just need to think about the issues.
Next case, Deer Trust Management Investment LLC, case number 2025-1403, Code Officer Alan Jonason, page 17 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Morning. I do. Ingrid Vossenbelt.
Anton van Heusen.
Good morning. We've met. Long time no see. All right, so this is case number. What is this case number? Page 17. Okay. But this is an LLC, which name I have not seen before. All right, so what's going on the property?
This is, address of the violation is 4335 East Garden Street, Inverness, Florida. Property owner is Deer Trust Management Investment LLC. This property is .31 acres and is zoned MDR and was purchased on 7 April 2022. I have good service via customer request for extension and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 20 August 2025, and aerial photos from the property appraiser's website dated 8 October 2022 and 3 July 2023. Exhibit B, a copy of the
I'm sorry, Mr. Jones, can you
Yes,
repeat the dates? Because I thought I heard a 2025, a 2023, and a 2022 date.
You did.
Okay, all
So-
right, I want to make sure I got it right.
Yeah, because the overheads are from the property appraiser's website.
Okay.
And they're from 22 and 23.
Okay, thank you.
Yes, sir. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the continuation letter, a copy of the pre-hearing order, a copy of the SunBiz, and a copy of the property appraiser.
Well, tell me what's going on.
Sure. So there was site modification done to a vacant lot.
Okay. Were you, all right, we'll get into that then. You may remember, I'm not trying to pay attention. Can you take a look at these documents and let me know if you have any objection to them being evidence?
Excellent. Yes.
Okay. All right, then without objection, what's been proposed as exhibits A and B are evidence, and I'll just take a quick look. Okay. So I see the 2025 photo, I see the 2022 aerial, I see the 2023 aerial. Okay, so Mr. Jonason?
Yes, sir. On 20 August 2025, I conducted my initial inspection and observed the property to be in violation with grading, site modification, and trees removed. On 20 August 2025, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance I mentioned earlier. On 2 October 2025, I conducted research with no permits issued, and a notice of hearing was issued. As of my final inspection on 16 December 2025, the property remains in violation, and I have had contact with the property owner. Joanna Coutu from Land Development is the expert witness.
Okay. Ms. Cadu, is there anything you want me to know before I speak?
No, as of yesterday, there were no building permit applications. It's an MDR lot and 0.31 acres.
Okay. All right. So are y'all contesting whether there's a violation on the property?
Yes, we are.
Okay. All right. What's going on?
I'd like to read our testimony.
Yes.
Good morning.
Good morning.
My name is Ingrid Vossenbelt. Next to me is my husband, Anton van Heusen. We reside at 12050 South Pleasant Grove Road, Floral City, and we represent our entity, Deer Trust Management Investment. We have brought with us a written statement of our testimony today, which I will read out to you. We would like to submit this document into evidence. We have the original to give to you, and a copy for the county, if they want this, and I'd be happy.
And what you're talking about is essentially, this is going to be the written version of what you're going to put on the record.
Yes.
Okay, sure. If you want, why don't you give a copy to them now, and at the end, when you're done reading it, we'll move it into evidence.
The original.
I'm going to wait till you're done talking, because you may deviate, there may be issues.
Yes.
But
All right.
once you're done, I'll take it.
All right, perfect. Okay, so on September 2nd, 2025, Citrus County Code Compliance issued notice of violation for case number 2025-01403, the NOV, concerning 4335 East Garden Street, which we will call from now on the subject property, alleging a change or development of a vacant lot without a building permit or development order under Land Development Code Section 4002, Exhibit 1. That's the same as Mr. Jonason brought in. The NOV, however, fails to specify the exact nature of the violation. Based on subsequent communications with Code Compliance and public records, it appears that the alleged violation relates to site modification at the subject property without a permit. So we had communication with Code Compliance after the notice of violation was received. We contacted Citrus County Code Compliance Officer Mr. Jonason and requested him to clarify the NOV. He declined to specify the violation and directed us to file a public records request, which we did. So the public records documents, and I had a meeting with Legal Secretary Code Compliance concerning Ms. Peros regarding the notice of violation. The records obtained through the public records request consist of the notice of violation together with a telephone complaint form by Mr. Williams, a photo dated August 20, 2025, and data of the owner of the subject property obtained through the Citrus County Property Appraiser's website and Sunbiz. The records that we obtained also contain a summary of the case and a so-called event log, which we will bring into evidence as Exhibit 3. On October 8, 2025, I met with Ms. Laurie Speros, Code Compliance Legal Secretary, who provided 2 additional photos from the Property Appraiser's website, one dated October 8, 2022, and the other dated July 3, 2023, Exhibit 4 in our testimony, attached to our testimony. According to Ms. Speros, these 2 photos were part of the file and should have been submitted to us through the public records request, but they were not among the documents we received. From the public records request and the photos handed to me by Ms. Speros, we learned the following. Citrus County Building Department, by way of Mr. Tim Williams, noted on August 13, 2025, that a lot had been cleared without a permit, without any further clarification. On August 20, 25, Mr. Jonason, Code Compliance Officer, conducted an inspection for site modification and observed a cleared lot. He intended to conduct further research to verify when the site modification had taken place. After conducting further research, Mr. Jonason determined that, and this is a quote from the summary obtained through the public records request, the property was cleared between October 2022 and May 2023. Aerial photos from the property appraiser were used to make the determination, end quote. The aerial photos from the property appraiser that Mr. Jonason refers to appear to be the two photos that Ms. Peros handed to me on October 8, 2025. And they suggest that the violation involves tree removal on the east side on the subject property in the period between October 8, 2022 and July 3, 2023. Excuse me. Please note that the latter date, July 3, 2023, does not match the dates stated in the summary that was obtained through the public records request. Now, before we get to the nature of the alleged violation, we question the accuracy and relevance of a complaint filed on August 13, 2025, and an alleged violation that supposedly occurred at least 2.5 years before that date. Obviously, Mr. Williams, as a building department professional, was triggered by the appearance of the subject property on August 13, 2025. But Mr. Jonason, as code compliance professional, could not confirm any violation at that time. Only after digging into the archives of the property appraiser could he come up with photos that may or may not confirm that lot clearing took place late 2022 or early 2023. Now, the nature of the alleged violation. On August 20, 2025, Code Compliance observed a cleared lot and concluded that the lot was cleared more than 2 years before, namely in the period October 22 through May 23. Evidence was presented by way of two photos dated October 8, 2022 and July 3, 2023. Based on the evidence presented by Ms. Peros, the two photos mentioned, we can only conclude that the alleged violation involves tree removal without a permit on the eastern side on the subject property close to the property line. It is still unclear why Mr. Jonason determines that the alleged violation occurred in the period October 22 through May 23, while there is no photo or evidence in the file reflecting the subject property in May 2023, or earlier than May 2023, to show any change compared with the photo of October 8, 2022. We may conclude that Mr. Jonason's allegation regarding the violation fails because of lack of evidence. If the Special Master does not agree to our conclusion, then the following evidence will be presented to contradict Code Compliance allegation. On August 13, 2025, Building Department's employee, Mr. Williams, noted that the lot had been cleared without a permit. He is wrong. Fact is that two neighbors to the north, to wit, Mr. Eric Bloom, residing at 4362 East Bennett Street, and Mr. Boudewijn Kroon, residing at 4348 East Bennett Street, had complained about excessive growth and accumulation of vegetation on the subject property and two neighboring lots. All three lots are owned by entities owned by us too, my husband and myself. Mr. Eric Bloom filed a complaint with Code Compliance on May 9, 2025, case number 2025-00731.
Can you give me that date again? I'm sorry.
The date?
May 9th?
Yes, 2025. Case number would be CE 2025-00731 for lot 4347 East Garden Street, which is in here as Exhibit 5, and case number 2025-00732 for lot 4379 East Garden Street, which is enclosed as Exhibit 6. And the other neighbor, Mr. Kroon, complained directly with us as the owners of the subject property. At the request of the owners of the two neighboring properties and the subject property, landscaper Mr. David Crabtree acted. he removed excessive growth and accumulation of vegetation from the 3 properties, as well as household trash and construction debris that originated from the surrounding construction sites. The 2 neighboring lots were graded and subsequently sodded, since the homes on these lots were nearing completion. So the NOV for these 2 neighboring lots were corrected. The subject property was not graded nor sodded, just maintained in good and clean condition like Mr. Crabtree had been doing in the past. Neighbor Crone was also happy with the work that was done. Shortly after Mr. Crabtree was done with his work, obviously, Mr. Jonason took a picture of the subject property on August 2025. Notwithstanding the above, the notice of violation is based on a misinterpretation of aerial imagery. Aerial photos from the same source that Code Compliance used to determine the nature and date of the alleged violation, namely the Citrus County Property Appraiser's website, will be brought into evidence to contradict Code Compliance allegation. I would like you to take a look at the photos that we will bring into evidence. There are like 7 from different dates. I will just read them out. You don't have to look at them right now.
I don't. I want you to conclude your testimony so that I can look at it and we can talk about it.
The Citrus County Property Appraiser's website from December 30, 2009, Exhibit 7, February 18, 2014, Exhibit 8, January 14, 2017, Exhibit 9, January 17, 2019, Exhibit 10, October 8, 2022, Exhibit 11, and July 3, 2023, Exhibit 12. They show no trees present on the east side on the subject property. Exhibit 11 and one of the 2 photos provided by Ms. Spiros, dated October 8, 2022, suggest that the crown of some trees may be hanging over the subject property, but the trunks of all trees were on the neighboring lot and not the subject property, as Exhibits 7, 8, 9, and 10 clearly show. Based on these photos, it is clear that no trees existed on the east side at the subject property from 2009 onwards, and that therefore no trees could have been removed from the subject property. And it's biologically impossible for trees to have grown to the size of protected trees, which is 4 inches or greater in diameter or 12.6 inches in circumference at breast height between the years of 2019 and 2022. In case the Special Master is of the opinion that the photos from the Property Appraiser's website presented by Code Compliance and the owners contradict each other, or that it should not be excluded that some trunks were physically grounded on the subject property, we must look for other supporting evidence that substantiates our position. There is no evidence that trunks, if any at all, on the east side at the subject property were protected trees measuring 4 inches or greater in diameter or 12.6 inches in circumference at breast height. The Citrus County Building Department possesses professional expertise in distinguishing cleared lots from violations. It filed a complaint in August 2025. Their complaint shows they consistently report violation, and we assume this is done regardless of who owns the property. The building department inspected the adjacent lot, so that would be 4347 East Garden Street, many times since December 2022, when construction started, and approved tree removal in December 2022 or / January 2023 on this lot. Had trees been removed from the subject property, the inspector would have no doubt observed and reported it. Only in August 2025, the building division filed a complaint about a cleared lot without any further clarification. The absence of any complaint at the time of construction and tree clearing strongly indicates no tree removal occurred on the subject property. Mr. Chris Matzer, manager with Vandervalk Construction LLC, and Mr. David Crabtree, subcontractor hired by Vandervalk for clearing building lots, provide sworn affidavits confirming that no trees were removed from the subject property. We have those affidavits here as Exhibits 13 and 14. Would you like me to read those?
No, we'll talk about, they may have objections to those, so I want to take those up individually with
Okay.
you.
All right.
I presume the county will allege it's hearsay, and then I'll have to talk about whether I admit it as hearsay, because I'm allowed to admit hearsay in a hearing like this. But I want you to finish your testimony, because I'm going to have questions for them about your testimony.
Okay, sure. So the testimony of both Mr. Matzer and Mr. Crabtree rebuts the assumption underlying the notice of violation. Our conclusion, the notice of violation, case number 01403, is not supported by credible evidence. The county's reliance on ambiguous aerial imagery and unsupported conclusion fails to meet the burden of proof under Section 4002. The evidence presented by the owners, being us, including aerial photos, neighbor complaints, and sworn affidavits, demonstrates that no trees were removed from the subject property. We can testify that at no time did we or any other third party ever undertake construction, grading, excavation, or tree removal on the subject property. At no time did we or any other third party physically change the subject property. We have no plans to build on the subject property. Vegetation removal from the subject property has been limited to weeds and debris consistent with responsible property maintenance in order to avoid the issuance of a notice of violation against the subject property. Tree removal only occurred on the adjacent lot located at 4347 East Garden Street as confirmed by our evidence presented. Accordingly, the alleged violation is unfounded. We respectfully request that the Special Master dismiss the notice of violation for case number 01403 against 4335 East Garden Street. We swear to the accuracy of the information that is in this written testimony.
Okay.
Thank
Sir, do you swear to the accuracy as well?
Absolutely.
Very good. So I heard a lot of compelling evidence about tree removal, and we'll get into that. I also heard you say at the conclusion that there was no excavation, no grading. What about fill? No. Okay. Because that's my question when I look at page 1. I mean, to me, I look at the dirt and I say, that looks like fill to me. No. But that's not. No. So, I mean, is that just the soil that's on the property? It's kind of a orangey type soil?
That is the soil that's on the property.
Okay,
Yeah.
no, that's what I'm asking.
Yeah.
Okay. Have you shared any of your testimony and exhibits with the county before today?
No.
No.
Mr. Jonason, did you hear anything that makes you rethink your case?
No, sir.
Okay, and why is that?
Well, because the site was modified. We're not even concerned about the trees because, again, she mentioned that they're on the borders. There is none in the aerials, but the site was definitely graded. You can tell by the overhead, and you can also tell by the final picture that I presented as evidence.
And so tree removal is not a part of the county's case?
No, sir.
Okay, and so what specifically is so I also agree, I mean, I agree with them based on the aerials. I don't really see the tree removal.
It's hard to determine.
Yeah, so
Absolutely.
I think that's not going to be at issue. So to the extent that tree removal is a part of this, we'll exclude that. Then what remains is...
Can I say something? I'm sorry
Okay.
to interrupt. The two photos that were presented to me by Ms. Spiros, October 8, 2022 and July 3, 2023, if you compare those photos, you have them over there.
Yes.
The only thing that stands out could be, I mean, nothing else stands out, but maybe the trees that are, so that's the reason why we've been...
I disagree. I mean, I think that this is why, I'll get into your evidence. I want to see your exhibits. I want to see everything. But to me, it does look like there might be, and your evidence may rebut it. It looks to me like there might be grading and fill. But I want to understand the county's case. So it's not tree removal. What exactly is the county's case?
So again, it is grading the site, modifying the site, removing vegetation.
But let's
and
set
possibly
aside
bringing
modifying. Because what I want to know is what is the modification? So it's grading.
Possibly bringing in fill dirt. It's hard to determine, but you can see that the property is very flat. It looks ready for a house to be built, Matter of fact, they're building a lot of houses out there at IV4.
Okay, but let's just slow down.
Sure.
So grading, the county's case is grading, fill dirt, because grading encompasses leveling the property.
Absolutely.
Okay.
And that takes all the it modifies the site.
Do you think that it violates the county code to remove grass if it's just a lot of grass?
Absolutely, it's a vacant lot. It cannot be touched until a building permit has been issued.
What about unprotected trees or, below the 4-inch diameter, or they can't remove?
If they're a nuisance tree, of course.
So it's the county, I just want to make sure I understand. So there's no tree unless it's a nuisance tree that they can take down from the property while it's vacant?
Absolutely. You cannot take down trees.
Is that your understanding, Ms. Harrison?
At this point, sorry, I keep forgetting I have to turn that on. At this point, for the modification of these lots, then that would be the county's position, is removing the trees would be a substantial modification, material modification of the property, and that would trigger a site modification case.
And they can't remove grass?
If they're modifying the lot, then, such as grading it, if the grass just dies on its own, they're not doing anything to it, then there's nothing we can do about it. But if they're going in and removing it, you can't remove the grass without grading and affecting the dirt underneath it. It's not just removing one single plant. Like if they went and picked one blade of grass, then obviously that's not going to meet the modification requirement under the code. But if you're going in and clearing everything off of the lot, including the grass, that's a modification of a vacant property, and that should not be getting done without some sort of a building permit or development permit.
Well, in the code section, it says, no development allowed by this code shall be established, changed, or altered, and no building, so no development.
Then it falls under the making of any material change in use or appearance of any land.
What if the property is covered in dead leaves? No, now we have now I'm worried. Now I'm really
Your Honor
worried.
has already established that precedent that you said dead leaves do not count.
I don't know. I might reconsider that. I mean, now I'm really concerned with the county's position, because if it's saying in one case that a bunch of dead leaves on the property, are a nuisance, but then in another case it's saying that a bunch of dead leaves can't be removed, or, because it would be an accumulate. I mean, it's a material change in appearance. It covers the property. I'm really worried about this. I don't think the code can be read to say that, something's got to give. Something has to give here. And I'm not sure what it is, but is the county so sure it's consistent?
Yes, it is consistent. The two cases are different because the other case involves developed property. And that is where we're protecting against the nuisance of mosquitoes and accumulation of junk and debris on developed property. Here, this is not developed. It's intended to be not developed. Trees naturally drop their leaves. We would not...
You just said material appearance. You were
Correct,
hanging your hat on material appearance.
Correct, because of something that the homeowner is actively doing.
It doesn't say that in the code. It doesn't say that. It doesn't
would
say
have
that
to
in this
be-
code section. So y'all read it really broadly.
The carrying out of any building activity. So in the making of any change, they're not making a change if the
They
leaves
have
are
to go
doing
onto the
what they
property and
naturally
remove the
do.
leaves. That's a change. They're going and doing that.
No, you just said that the leaves are there, and that's what
Yeah.
you're worried about. So
Right.
they're not making that change. Nature is making that change.
Well, that's right. I'm saying if they remove the leaves, which you've requested in another case.
Correct.
But them removing leaves here would be a material change in appearance, and under your reading of material change,
No.
it's a violation of the code.
No, it would not be a material change.
Well, I
because
don't think it would be, but I mean.
The land would not be changing. Removing grass changes the land. Removing the leaves does not change the land.
And you wouldn't
It does
use
if they pre-exist.
You wouldn't use a grader to remove leaves, sir.
Well, I agree. I'm not talking about grading. I agree that grading, ends up, so we're setting that aside. But I'm talking about grass removal. And so I'm worried that even on a material, even on a,
But in this case, we're not talking about leaves, we're not talking about anything that happens in nature naturally. This is the owner making a change which affects the land, and with grading and possibly fill.
grass occurs naturally too. I mean, I'm just trying to say, like, sometimes grass doesn't look good, grass thins out, grass gets removed. I agree that resodding, well, if resodding is a material change in appearance, then taking it out would be too, under your code section.
Correct.
Mr. Johnson, were you going to say something?
Yes, sir. So just to add something, on 11 September, I spoke with yes, ma'am, I'm sorry.
It's fine.
And I explained the violation to her, and she indicated to me that they were just trying to make the lot look better, and then requested the open records request.
Yeah, I mean, all right, well then let's...
And may I interfere a little bit? The question was, our fear was that we got a notice of violation in the future because of accumulation of debris or grass too high or whatever. The code compliance officer said, no, we never do that. You know, if it is a vacant lot, we never do that. He's wrong. I've got documents here that I had to clean lots in the past, vacant lots, from code compliance, although back then they were a little bit nicer and more polite by sending me a letter and say, hey, can we meet and discuss it? Nowadays, they just send you a notice of violation without any discussion. They don't even tell you what the violation is. But anyway, I have here 2 lots that I had to maintain as well, and vacant lots. And these lots are not in the field. This lot is not in the field. It's surrounded by homes. So what happens is, and I've got my phone for today, I left it home, but I took a picture last week. They construct fiber optics now in the ground for every home. What do these guys? They park everything on that vacant lot because that's the only vacant lot available. So before that, the builder put dumpsters over there. I called him and said, take it away. It's not a place for dumpsters. Oh yeah, we'll do that. I can lift. So they did. They took it out in the end. So they used that lot. There's construction debris from the surrounding construction sites. Three sites are under construction or are finished, just finished. So they lose stuff. They lose concrete. They lose. And we picked it up. We were busy 2 days to pick up all the trash, McDonald's trash, all the trash. People sit there, dump it away, because we were afraid that we would violate again and stand here again. We thought we'd do good. So then the neighbor complained and said, hey, all your aggressive weeds and all the rest of it, do me a favor, I have a nice lawn over here. Can you please cut it down? Otherwise, we file a complaint with code compliance. You know, things like that. In the past, it happened, so we thought we'd do good instead of standing here again.
And why would we be grading a lot if we don't have an intention to build? I mean, who would be grading a lot if you don't start a new construction?
Well, what else are you going to do with the lot?
Nothing, just keep it there.
Keep it there.
Maybe sell it in the future.
I don't know. Okay. That's true. They have gone up in value. I remember 5 years ago when you could get them for, $3,500 a lot. Now they're going for 30. But
and if we do,
but everyone else is building. So I mean,
no, we don't build there.
If we do intend to build, we'll definitely get a permit. I mean, There's no doubt about that, but.
Let's go through your exhibits. So I want to make sure that you lay the evidentiary record, that I have the information I need. Is everything in these, all right, let's see. Do you have a copy, Ms. Harrison?
Yes.
Okay. Let's go through them one by one. So.
The written testimony is cumulative at this point since it has been read into the record. I also think it creates a little bit of confusion because they've pre-marked the things attached to it. So if this becomes exhibit, whichever number or letter we're at, it just could create some confusion. So just for the testimony portion, that's our position.
Just going to review it real quick. All right, y'all have already sworn to the accuracy of it, so I'm going to construe this as a declaration or affidavit. To the extent that there's any difference between this and what you said, you have to rely and get a transcript of the hearing if anything happened, but I'll accept this as Exhibit 1. I know we're already, well, no, actually,
That's
you
why I
guys
was-
have A and B. Yeah, then you know what? I'll keep that. They've got letters, you've got numbers. This will be Exhibit 1. And
What they've pre-marked as Exhibit 1.
Yeah, maybe.
that's true. So
That's-
this will be Exhibit 0. And then Exhibit 1, let's take a look at, has already been introduced, I think, as
Yes.
evidence.
We would object to cumulative and already in evidence.
All right, it'll be Exhibit 1. It is cumulative, but it's quasi-judicial hearing, and because it does match up with Exhibit 0, it doesn't matter. So Exhibit 2, let's take a look at this. Is Exhibit 2 the documents responsive to the public records request?
Yes.
So these are everything you initially got in the responsive?
No, plus Exhibit 3, that's also part of the public records request. That's the summary and the legal, what is it now,
This was a complaint form.
how do you say that?
Okay. Exhibit, let's look at Exhibit 3 real quick.
What they've marked as Exhibit 3?
Mm-hmm.
Okay.
What else would it be?
Making sure I have the numbers right.
That is part of the public records request.
Okay, okay. So I'm now looking. Okay, I mean, what's the county's position on Exhibits 2 and 3?
We have no objection to the first page of Exhibit 2. Pages 3, 4, 5 are all cumulative and duplicative. I believe pages 4 and 5 are already in evidence twice. Pages 5 and 6, we have no objection to, and page 7 and 8 are also already in evidence.
Okay, overruled. This is Exhibits 2 and 3.
As to Exhibit 3, we would object to relevance.
Okay, overruled. Exhibit 4, let's see. I think already also in evidence.
I believe so, and if so, we would object to that.
Okay,
Cumulative.
overruled. It's Exhibit 4. It's not a federal trial. I'll just put on the record, I mean, the purpose in admitting something that's already in evidence, obviously no harm, but second of all, maintains the order of the testimony and for organization purposes. So I'll accept a standing objection from the county to the extent that there is anything reduplicate. You can feel free to assert that in any appeal, and I'll just have a standing overruling of the objection. So Exhibit 5, same thing?
Actually, no, this is relevance. The addresses cited here are not the address that is currently before Your Honor and have nothing to do with this case.
What is the basis for Exhibit 5?
That was to show you that the two notices of violation were issued in May 2025, telling us that we had to take care of the excessive growth, whatever. And this is a neighboring lot. So these are three consecutive lots. So the two were issued a notice of violation because the one back neighbor had filed a complaint. The other back neighbor had filed directly with us. So it was like, okay, let's take care of that lot as well before he goes over to code compliance and files another complaint. Let's just take care of them all three together and, yeah, okay.
Okay, so...
While the two were building lots and was graded and put sod on top of it.
Yes.
There was no grading on the subject property, nothing, just take the vegetation down and clean the lot, so to speak.
Yeah, I mean, I'm just trying to understand the why I'd put this into the evidentiary record. I think I understand what you're saying is like, okay, we had problems on other properties, we fixed them, but what the county said to us there was excessive growth and accumulation. I mean, what kind of stuff did you remove? Or what was there on the other properties?
On the building lots?
Yeah.
Also, grass
Tall
and
grass.
construction debris and household trash and I mean
construction debris.
Yes, but the contractor, Vandervalk, went in,
filed for bankruptcy.
So he hadn't been doing anything to these building lots for maybe in a year. So these got neglected. So he filed for bankruptcy late April. And then the back neighbor must have thought, oh my goodness, now nothing's going to happen. Let's file a complaint because this looks like, well.
I got you. So, Mr. Jonason, you issued the notices. What did you see for the excessive growth and accumulation?
I'm not for sure.
Okay. I mean, I know you have 1,000 cases, but okay.
I'm not for sure, to be honest with you. I know I had a couple over there.
Guys, I just have a hard time understanding why it's relevant for this case.
Well, it's just so to show that we were trying to be proactive for the subject property because we had been issues for the two neighbors.
Okay, I'll accept it for that purpose. I'll accept it for the purpose. Exhibits 5 and 6, limited relevance, but I see what you're saying. So in other words, to the extent that you took action on the subject property, it was due in part because you have these other cases where you're trying to deal with it. Okay.
And to add something to it, we talked with Mr. Jonason, and I told him I'm going to do it because otherwise I get a notice of violation. He told me, no, you don't have to worry. We never asked that for a vacant lot. I said, you're wrong, because my experience in the past is that vacant lots surrounded by homes, you issue a notice of
Mr.
violation.
Johnson, do you remember that?
No.
Okay.
No, I do not.
All right. I'm sorry, Ms. Harrison, did you want to say something?
No, Your Honor.
All right. Exhibit 7, what's been marked as Exhibit 7. This is the aerial from 2009. County's position.
We would object as to relevance. The trees are not at issue here. The testimony has been that the trees are not at issue, and the only reason these are in as evidence are because of a tree argument. And that's
I think you're right, Ms. Harrison.
7 through 10.
I think you're actually right, Ms. Harrison, but I'm going to admit them because I think they do show the condition of the property. I'm interested in the grading. I'm interested in the way the property looks, and looking back in time helps me. So I'll admit Exhibits 7, 8, 9, 10, not for the tree issue, but for just the status of the property.
And I think 11 or 12 are the already in evidence objection and overruled, Your Honor.
Okay, so that's 11 and 12. And then let's talk about these. So let me take a moment to look at them. Wow. What's the county's position on Exhibit 13?
We would object, Your Honor. Obviously hearsay, we don't have a chance to cross-examine this individual. And also relevance, it appears on its face to be mainly about tree removal again, which is not at issue in this case. And again, the attached exhibits in evidence already.
Normally, on the matter of hearsay and cross-examination, I would not be sympathetic to the objection. The problem with this affidavit is that it does not state that it's made from personal knowledge, although I might be able to imply it. Again, that's a formality I might not normally require, but then there's paragraphs 15 and 16. I really don't have a problem with 1 through 14. No other party has performed any development or construction of any kind on the real property. How would they know that? I mean, how would they know unless they sleep there and breathe on it? How would you have personal knowledge that no one else went? You might have personal knowledge, but I mean, they might. I don't. The allegations in the notice of violation are false. I think that's not a credible statement. He can make that statement for himself. He can make that statement for his company. I don't think he can say that the entire universe of people, unless he had security and managed the fence on there and was there 24/7. So without cross-examination, I'm going to only allow it for paragraphs 1 through, well, then again, I can't do that because it's not the property in question. Okay, I'm excluding Exhibit 13 for the reasons indicated on the record. Let's look at Exhibit 14. And see, he does say that he has personal knowledge on paragraph 1 of Exhibit 14, which is necessary. Let's keep going. Right, by the way, just again, I mean, that's why personal knowledge matters, because he can't possibly testify to 15 and 16 in Exhibit 3 without personal knowledge. So back to Exhibit 14, I own and operate a small landscaping, okay. Number 3, okay, 4. Mr. Jonason, did you ever see on this property weeds, trash, or construction debris, the subject property?
I only went there the one time, and I saw that.
And you
it
took,
had been,
so the
there
photo
was
indicates what you saw?
Yeah, there was nothing else on.
Okay.
I have not been back there since
Okay.
because I used the overhead for further research.
All right. Paragraph 6. The river I never... Oh, man. You know, they say that pigs get fat and hogs get slaughtered, and that 14 is a hog statement. The allegations in the notice of violation are false. You know, you can't, it'd be like if you have a third party who doesn't know and isn't there all the time, how can you necessarily say so? It's not credible, but it's not credible. But,
Okay.
But I find paragraphs 1 through 13 relevant, or somewhat relevant, in that he says what he did on the property. He says that he helped clean. That's consistent with the testimony offered. That's also in the public record statement that they were trying to beautify the property. What's the county's position on this affidavit?
Just as to hearsay, since we can't cross-examine this individual.
You were going to say something, sir?
Yes, the problem I have with it all is the following. We asked politely, what is the violation? We didn't get an answer. The code compliance officer didn't want to give an answer. He said, go to file a public records request.
Site modification.
Site modification was the only thing. We didn't know. So we were thinking, what is it? Because we're not aware of anything. So what could it be? We thought, so we got the photographs. That's all we got. And what's in the public record. So we thought, they say, have a look at it. Between 2022.
You can tell by looking at the pictures, you can tell what the violation is. Well, I mean, if
That's
you look
it.
at those pictures from October 22 and July 23, what's the relevance of a picture made in August 2025 if the violation took place somewhere between October 22 and May 23?
And what is the violation
And what
then?
is the violation?
We had to find out. Look at it and find out. So we thought probably they mean removal of trees. Now we're here today. For the first time, we hear it's not trees. Why don't you give a straight answer? Why don't you tell us this is the violation?
Look, the point of this hearing is to find facts. So my job is to make a determination of what the facts are. So,
How
you
can
know,
we defend
trees-
ourselves then? If we don't know what the violation is, how can you defend yourself? Tell me. We did everything we could. We made a whole story about it. We did our best, the best to our knowledge. But we didn't know how to defend ourselves because we didn't know what the violation was.
So I think that's a potentially compelling point. But the issue when you get a notice, I'm just going to tell you my understanding. And of course, I encourage you to retain your own legal counsel. But if this was a regular civil lawsuit, you know, and someone has to allege in a complaint something against you and be very specific, you breached the contract because of Section 13. You didn't deliver the blueberries on time. Then you do have to be, and you have a right under due process to have that pleading be laid out correctly. This is a quasi-judicial hearing. Now, all I'm saying, you do have a right to due process, but what due process consists of is, hey, here's a notice that there's a hearing. I'm going to get in front of Special Master Waugh, and this is the notice of violation. Now, if you look at the code section, LDC 4002A, I see your point insofar as it could be anything. I mean, we've talked about it being anything from grass removal to, you know, other development could be a lot of things. Material changes could be a lot of things. That said, I think due process has been satisfied. Whether we like it or not, this is the rule. You get a notice of violation, you show up the hearing, you tell me what you think is wrong. Now, if you are asking for a continuance to change your defense or better prepare for the hearing, I would entertain that. Similarly to the county, if the county sees this affidavit of David Crabtree, and I was inclined to admit the affidavit, except for paragraph 14, which I would not allow, then, you know, the county can have me issue a subpoena and continue the hearing to the next hearing. I mean, but I don't, I mean, what I take this affidavit for is essentially the proposition that he didn't do anything. Right. This guy didn't do anything. It's relevant. I mean, it's not dispositive, but I think it's relevant. So I'll admit it as part of their defense, except for paragraph 14. Paragraph 14, by the way, so that you guys understand, it's never okay in any kind of an affidavit because it reaches an ultimate fact. My job is to determine whether it's false or not, by the way. Well, I take that back. He can say what he wants, but I don't accept it. Paragraph 14. So is that the last exhibit in the,
Yes.
That was it?
Yes.
Okay. So we've eliminated the tree issue. Now the question is grading and fill. And what is the county asking for in this case, by the way? I assume it's a one-time fine.
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative cost to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation.
Okay. And you make that request normally, my understanding is that my authority goes up to 15,000.
Yes, sir.
Okay. Have I ever done that?
13.
I did 13 once, okay. That was a bad case. All right, so what I want to do is I want to look through these aerials. I want to look at these aerials. By the way, Ms. Katu, I never should have mentioned that the agenda was short to you. I never should have said that.
Multiple people mentioned it, and I told all of them not to.
Okay. Because I'm interested to see what the property looked like. I don't know if I can tell or not, but I'm interested. You know, it does look like the color of the soil. You know, I'm looking back at. When did y'all buy the property?
2022.
2022.
There's no filter whatsoever. No excavation, nothing.
I mean, the problem I'm having is looking at the aerials. It looks like the soil color is consistent everywhere. I can't tell that that's fill, but it does look like fill in Mr. Jonason's photo because it looks like it's been placed on top of grass. That's what I don't understand.
It's not. Believe me. It's not.
I mean, the alternative is that, I mean, how did it get that way then? I mean, what did y'all do? Did you just remove grass? Why does it look like it's cleared?
What we tried to explain today that the other 3 lots next to it were, let's say, cleared, graded before sod was on it. Mr. Crabtree pulled piles on this lot before he could move it away, haul it away, right? Okay, that happened. There was a dumpster on it during that time and things like that.
Okay, now I understand what you're saying. Okay. And that might be consistent with why I see this and my brain keeps saying, well, it looks like something was done. but it also might be consistent with what Mr. Jonason's saying, which is, you know, we've seen a lot, we know what cleared sites look like. Now, by the way, normally when a site is cleared, it doesn't have this shape, right? Like normally when a lot is cleared, I mean, you agree with that, Mr.
Yes, sir.
Jonason, right? So what you're saying is, you know, Mr. Crabtree's doing work on these other sites, and he needed somewhere to put something. Okay.
Yeah.
Okay.
But there's no fill dirt on it. It's not graded, nothing. So it's
do you have any, well, does the county have any examination that it wants to do of Deer Trust's principles?
Your Honor, can I actually look at Mr. Jonason's exhibits?
Yeah,
real
please.
quick?
Yeah.
I need them from you. You're the
You,
one-
you what?
I need them from you. You're the only one that
Yeah,
has the
okay.
copy.
So I have the exhibits. Let's see. I think these are yours. I'll take.
Thank you. And I apologize, I have not heard Miss Ingrid's last name super clearly, so I only have her written down as Miss Ingrid in my notes. I can't.
My last name was Vossebelt.
Vossebelt, okay. Ms. Vossebelt, how did the land get to be so flat? In the other photos, you can see there's contours, there's movement within the land in the other photos. This property as of August 20th is completely flat. There's no contours. How did that change happen?
Does it matter? Because the violation was done between October 2022 and July 2023.
Yes, it does matter. How did it get to be so flat?
I assume it was done because Mr. Crabtree had the dumpster on there. He had to pick up the whatever was there,
the piles
the
of
piles from the other
vegetation
lots
debris.
that he put there for just for the time until he got the dumpster. But these other two lots,
Thank you.
three lots.
Alan, can you please return this to Mr.
That's
Wall?
what I'm
No further
assuming.
questions.
That's,
I mean, if I was your attorney, I would have objected to that question. And what I would have done is, and the reason is that, you know, it presumes that there was a change to the grading, but I think it was a telling question to answer. But Ms. Harrison, here's the thing. Here, I'm looking at page 1 of County's Exhibit A.
Yes.
You're telling me that it's very, very flat, and I don't think it is perfectly flat in this photo. But hold on. And then I'm looking at these aerials. This is why I wanted to see the older aerials, because when I look at exhibit, let me go to exhibit 9, I mean, I'm not sure. Granted, it's not the angle you want to be able to assess curves on a property or height of a property, but I'm not sure. Like, Mr. Jonason, in your opinion, I mean, is that perfectly flat, the whole lot? Or just yeah, I mean, just, what is your observation? It is?
Yeah, in other words, and also if you look at it, it's the site, almost the size of a pad for a home. If you look at.
Come on.
Oh, gosh. Just getting back.
Come on.
so.
You must be from another planet.
I don't think you're completely wrong about that, but I don't think it is the size. I mean, I'm looking at what you're saying. You did say almost, and I think that was the right word to
Absolutely.
use. It's not
Absolutely.
quite.
It's a small lot as well.
Is it? How big's a lot?
0.31, 0.3.
0.31?
Yes.
Same as all the other.
That's not a
One-third of
small
an acre.
lot, right? I mean, compared,
have-
well, maybe
I
by
have-
Citrus County standards, I don't
have 5
know.
acres, it's tiny. Tiny.
I come from the faraway land of Orlando, and we're lucky to have 0.24, you know?
But all the lots in that street have the same size.
Yeah, I mean, Okay, here's what the county's going to tell you, and this is the evidentiary record at this point, is that, you know, it doesn't really seem contested that whether it was intended as development or not, Crabtree used the property. It probably looks this way because Crabtree used the property. Why? Because it's a neighboring property and y'all were building next door.
Comcast does. Everybody does, because
Well-
it's the only vacant lot. But
Let
I
me-
can't ask the police all day and say, hey, away from this lot. I can't help that.
Well, the count, if you have construction, let's say that you're building on a lot that's vacant and you're surrounded by improved lots, then you don't have a choice, right? You do everything on the lot or not at all. And I think that's part of why we're seeing this, but at the same time, it's not. Is there anyone from the public who wants to be heard on this case? All right, I see a hand. Sir, if you do want to come up, I need your name and you need to be sworn in.
Christopher Nielsen?
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do. I mean, I'm just sitting here.
If you could, into the microphone, sir.
I'm just sitting here listening, and I've been around construction and building homes a lot. And from what this gentleman is saying, if the neighboring lots were building and they put a dumpster and stuff, because the lots are smaller, they put a dumpster on your property, you can't really police that. And you might have even let them, because what are they gonna do? Now, if they remove their dumpster, what we would do, if I was in this situation, I would have the lot box blade to remove all the debris that missed the dumpster. So there you could come in, okay, there might have been a tractor out there to do a little bit of an area, because if they missed throwing the concrete and the wood and all the stuff they do from the construction into the dumpster, and it was all over the ground, as a builder, I wouldn't want to leave your lot like that. I would go there with my front end loader and a box blade, and I would pick up all the debris, and I might smooth it out a little bit. So if the whole lot has not been cleared or tractored, just a smaller area, that sounds like what it probably was. Just sitting here thinking and listening to you all real closely. That's all I had to say.
Thank you, sir. Is there anyone else from the public who wants to be heard on this case? In this county, because of this code section, grading is policed, you know? It's enforced. Ms. Harrison, is there anything else you want to say?
No, Your Honor.
Mr. Jonason?
I'd just like to add to the record, a property owner is responsible for their property. In other words, if it's a vacant property and somebody puts something on your property, it's your responsibility to remove that item.
It is. Yeah, I mean, I think this is not a, I mean, it's, I'm going to have y'all sit down while I think about it. Again, I'm so sorry, guys. Look, you've hit me with some tough ones today. All right. Let's get some people out of here.
Next two cases, William Nimnick. Case numbers 2025-1998 and 2025-1999. Code Officer Robert DeNaro, pages 29 and 30 of your agenda.
Morning, everybody.
Good morning.
All right, just,
Robert?
yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, sir.
William Nimnick.
Thank you.
Good morning, sir.
Good morning.
Good morning.
Your Honor, Mr. Nimitz had come in later during the proceeding, and not to interfere with speaking to Ms. Harrison. He had stated that there's two cases here. There's a case on junk and accumulation of debris, and also temporary residence of an RV. He acknowledged that my last photos were on the 15th. He had said he cleaned up as of the 16th. In regards to the gentleman that is living, he did acknowledge that somebody is living on an RV on the property, and he's going to go through a civil matter and trying to evict them.
Okay.
So I'm just, again, we didn't have a chance to plead a no contest situation here.
Oh, so basically, are you just asking for a time to comply?
Yes. Yeah.
Okay. I mean, how much time do you need?
To the matter of.
Well, let me go one by one. So
Okay.
you've got a junk case and a temporary occupancy
Okay.
case. So on the junk case, how much time do you need to clean it up? 2 days? 3 hours?
Like a week.
So, okay.
7 days.
So you think it's not that big on the junk scale?
Most of the junk and debris was on a trailer, so that could be.
Okay.
And that's already gone.
That's
Gotcha.
gone.
All right, so
It's
we're
just-
close. We're
It's
close.
just the perimeter of the property that needs to be cleaned up.
All right, then let me ask first, is there anyone from the public who wants to be heard on this case? All right, what's the county's recommendation on the junk case?
On the junk, I would recommend $50 a day.
Okay, so I'll grant 2 weeks on the junk case to bring it into compliance, 2 weeks, 14 days, and if it's not brought in compliance, $50 a day on that case.
Yes.
All right, now let's talk about the temporary occupancy case.
Okay.
How much time do you need on that one?
You're talking about the.
The fellow, the person that's living on
Yeah,
it.
usually you just use a crowbar or like a.
Well, that's the.
What, a blowtorch. Oh, no, wait, I'm sorry. For our viewers, that is a joke. It's not a good joke. I don't mean that. We use legal process.
Yeah, I mean, so.
Sir, I do want to emphasize, I have to say this for the record. I really don't mean that.
No,
That's
you're
just
fine.
legal process. Okay, consult a lawyer.
Like I've been trying to get him out of there, and it'll get to a violent point. So I don't.
You don't know how long it'll take.
Yeah.
So what is the vehicle? What's
a
the
trailer.
issue here?
It's a trailer.
It's a trailer. So you're trying to get rid of the whole trailer or someone inside the trailer?
Him and the whole trailer.
The trailer itself?
Yeah.
I mean, I feel like you can do that on your own property. I mean, what's the problem with removing a trailer or getting it towed somehow?
I think it's the person living inside of it. I think he's
It's
afraid
more
of
person.
the.
I want to get rid of. Like I've done so much for him, and he's the one that's done most of the stuff around my property. That's
okay.
Yeah, he's also part of the junk and debris situation.
All right, let me ask, is there anyone in the public who wants to be heard on this case? Okay. What's the county's recommendation?
The county's recommendation on this was $100 a day, considering the fact that somebody has lived more than a 2-week period in a
Do you have immediate health, safety, sanitary concerns?
I had emailed the health safety and in regards to trying to take a look at the property. I had not gotten back on that as of this moment, to be honest with you. Exactly. My concern was runoff. Also, in the middle of the property, there's like a shed-like structure that says shower, so I believe that there could be some sort of health concern there also.
Whoa, wait a second. We have to announce the arrival of Assistant County Attorney Beth Antrim, a legend in Citrus County legal circles. Okay. All right. Well, so, sir, here's the issue. I mean, I have to give a time to comply, but I don't want to give too long. So you're going to engage in legal process here?
Yeah.
Does the county have an issue with me doing 2 months?
No,
a chance
sir.
for him
No,
to...
I believe it's my first contact with this gentleman. I believe he's, saying all this in good faith, so I have no problem with it.
Okay. Then on this case, I will find that a violation exists, give 2 months to abate the violation, and it'll be $100 a day if not brought into compliance.
Okay.
Okay?
Thank you.
All right, thank you.
Thank you.
2 months, yeah.
Did you want to bring any more of the cases you're thinking about, or?
Nope.
Okay. Next case.
I mean, is there anyone still here for a case that hasn't been called?
Yes.
Okay, then I
Yes.
want to get them out, and
Yeah.
then I'll agonize.
Next case, Christopher Nielsen and Janelle Santora, case number 2025-501. Code Officer Erica Olson, page 28 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Ma'am, I just need to swear you in. You've already
Oh,
sworn.
I'm still sworn in, okay.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Please state your name. Diane Santor Janelle. You're welcome.
All right, good morning.
Good morning.
Good morning.
Or so much afternoon.
I know.
Yeah.
That's why I'm trying to get you out, so that you don't have to sit and watch me play Hamlet on these other cases. So, go ahead.
Eric Olson, Citrus County Code Compliance Officer. This is case number CE 2025-00501, Special Requirements for All Accessory Structures, a violation of Citrus County Land Development Code 3102 Alpha. The address is 7290 West Vineyard Drive in Homosassa, Florida. The property owners, Steve Nielsen and Diane Santora Janelle. I have good service via posting on the property and posting at the Lecanto Government Building. At this time, I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection. On the 24th of September, photos taken during my corrective action inspection on the 13th of November, and photos of my final inspection on the 15th of December. I also have screenshots from the property appraiser from 2014, 2019, 2021, 2022, and 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the hearing posted on the property, and a copy of my posting affidavit.
Right, tell me what's going on.
So this property is classified as vacant. It's a vacant property. They have an RV, a boat, or they used to have boats. I believe it's gone now. There's vehicles on the property. There's a pool. There's just, some things on the property.
So in other words, it's the county's case that this is a vacant, I assume, residential
Yes, sir.
zoned property that should be vacant but has stuff on it.
Yes, sir.
Okay, all right. Then
on,
I'd like to
Diane.
ask y'all to take a look at these exhibits. Just let me know if you have any objection to them, okay?
And I do want to correct the record. She said Steve.
I
It's
heard it.
Chris.
I heard it.
And that's because the gentleman that I bought the property from, his name was Steve. And we do have, we'll go back to that in a minute with the due process is a big issue right now too. That's not our property. What is all that? That's our property. We do use the property. We've tried to manicure it to me like a park. I didn't know you weren't allowed to use your property in Citrus County any longer. We have a pool on there because we do go swimming. We have structures on there. One of the structures we use to change and dry off and stuff in. This is it. That's gone. That was the guy, Steve, that owned the property, had some friend or something of his that was buying a home, and his RV was there. He was staying there until he closed on the home, and then something happened with the closing. There was a lien on it, and then they didn't get to close for almost 3 months, I think. The lien company
Well, before
held
we
it
get
up.
into that, I just need to know if you have objection to these documents. I definitely want to give you a chance to say what you need to say.
Other than this one here, I don't understand.
So there's a photo in there that you think is not your property?
This one here, I don't,
Yeah,
I've never seen any of this stuff here. What is all that?
that's the well house. That's when Steve was on there.
Oh, okay, I see
They're
that.
no
Yeah,
longer
no, they're all okay.
Okay. All right, then I'll admit the documents just so I can see them. They are evidence in this case, Exhibits A and B.
Okay, please.
All right,
All
thank
right.
you. Okay, you can put them in order. Now, then I'm going to wait for this. If you would hold on just a moment, because I want to see what's actually happening on the property before I let the county complete its presentation. Thank you. All right, let me just take a look. How big's the property?
2.1 acres.
Okay. All right, Ms. Olson, I'll let you complete your case.
Okay. This property was initially scheduled to be heard on the June 18th hearing, 2025. However, the property was purchased prior to the hearing date. On June 12th, I spoke to Mr. Nielsen by telephone and advised him of the open code compliance case and steps required to abate the violation, and requested documentation verifying that he is the legal owner, as the property appraiser records had not been updated. He provided the requested documentation in person. During that meeting, I advised him I was willing to work with him towards compliance. He stated that he intended to comply and apply for the required permits once he completed the current job that he was on. I advised him that this case could not remain open indefinitely. On September 24th, 2025, I conducted my initial inspection for the new owners and verified that no permits had been applied for or issued. The property remained in violation due to the presence of vehicle, boats, RVs, and other miscellaneous items. On October 8th, 2025, Mr. Nielsen contacted me and advised that he had hired a company to prepare drawings for a new permit application. An extension was granted at this time. On November 13th, 2025, I conducted a corrective action inspection and verified that no permits had been applied for or issued and that items remained on the property. On December 5th, I posted a notice of hearing on the property. On December 15th, I conducted my final inspection and verified no permits had been applied for or issued.
Okay, so I understand what the county's case is, and now is your chance to tell me what's going on.
Okay. I do have a lot of experience in this, okay? A lot of experience in buying and selling property. I've actually done 1,587 homes.
Wow.
So I know what I'm doing. I did a bunch of research on the property prior to buying it. Some of the research that I did, it's all in public records under permits. There's a whole paragraph in there that states that in 2020, they were going to remove a single wide that was out there. And there's subsequent pictures from aerials showing there was a home there. That was good for me. When you do what I do, you look for property that has improvements already on there so that you can capitalize on the resale, especially like now with impact fee. You know, now the impact fee here in Citrus County, I think it's like $13,900. So if you're buying a piece of property with a home that was previously on there, you're grandfathered in. You don't have to repay that. Same thing with well, same thing with septic tank. When I was at the closing, Steve, what's his last name? The previous owner told me about Erica and the hearing that was supposed to be like this. I contacted her, left messages on her recording a couple of times. She called me back. I said I wanted to attend the hearing that Steve was violating on. Let me go backwards a little bit. This whole process with so-called sheds, which I was explained that I'm in violation because there's sheds on the property and they need to be removed, which I don't understand why you can't have a shed like the well has a well house on it. So what, you're supposed to tear down the well house? I don't get the logic there. Anyway, they said that they had to remove the home that was on there, which they did. They violated Steve a couple of years ago for the same thing. He wasn't allowed to have sheds on the property. He said that he was going to go ahead and build a home. I said, well, that's cool because that's what I want to do. I'm going to build because that's what I do. I build. Once he started his permitting process, he got the permits and whatnot, this whole scenario went away. Well, he didn't build. He stopped. He pulled the permit and whatnot, and he had the property, I guess, for another year or so before we got involved. So anyway, he was recited again for having the structures on the property. And I was told that that's what the issue was. And I told Erica, I said, I'm not tearing down the sheds. I just paid $135,000 for the property because the sheds were there. Now, building department, if you go onto their site, one shed was permitted in 1980. One shed was permitted in 1985. One shed was permitted in 2001. And I do look at that when I buy something because I want to make sure they're legal and they're there, you know, and I'm not getting into a problem. I wanted to come here in June, and Erica said, no, don't do it. If you're the new owner, I have to serve you that there's a code violation there. Okay, I was like, well, I wanted to try to come in and talk, but okay, I'll do that. So she contacted me again and said she can't serve me because she doesn't have proof that I was the owner. She said, email me the warranty deed, which I did. Called her 4 or 5 days later. I asked her if she received it. She said, no, I can't receive emails from outside people, which I was kind of like, well, why didn't she ask me to email? I said, all right, whatever, I'll come over there and come and see you and bring you the warranty deed. I had a certified copy and show you that I'm the owner so that you can serve me. Now, here's where the problem arrives with that. The notice of violation stated that it had to be cleaned up and taken care of by October 3rd. I wasn't served it until October 7th. Where's my due process there? They wanted me to clean it up, the sheds to be removed, before I was even legally notified. She told me she couldn't do it verbally, that she had to serve me to make it a legal deal. That's why I drove over to the billing department and gave her a copy of my warranty deed. So I don't understand how you can serve me 3 days or 4 days after I was supposed to clear up the mess. As far as doing anything else, I'm trying to build a home on it, which that is going to happen. That's what I do. That's why I buy it. In the beginning, when I met her, I said, I'm involved with a project right up the road. It's right around the corner. And I showed her, I had just gotten the permits on that, and I was waiting for the home to come. Hence, that home is finished. It's up for sale, and we think we just got a text message that we do have an interested buyer, which is good because I need that money to do this project. We have hired an engineer to do plans for a home. I'm not doing a manufactured homes on this one, and that's what I did on the previous 1,580 homes, other than I've done 86 stilt homes here in Citrus County too, on the waterways and stuff. But I have a broken back in 4 places, so I might be in a wheelchair, so we don't want a mobile home. We want something on the ground, so we're architecting a house to be built out there. I did do the septic tank pump out, what you have to do for permits. That was recently done. I'm waiting on the engineering to get done to apply for a permit. The issue with the engineer, Mark, from CADTech, is he kind of put me back. He said he had to do all the projects he was working on that were involved with impact fees because they were trying to beat that increase. So I was like, okay, well, I'll have to wait. So we're waiting on Mark to finish that and close on the house that I'm doing so we can build the other house. I mean, I'm not going to tear down $35,000 worth of sheds when they were legally put there. In the paperwork where the county says that the house had to be removed in 2020, there's no mention that you have to remove your other structures as well. So why would you have to remove a shed that we use? For one, I have all my equipment in there that we maintain the property with, which you have been out there. You know the place looks like a park when we're there. We've maintained the property. It's always mowed every week. I mean, the property looks nice. One of the structures has a bunch of tools in it. Another structure we use for the pool and to go. Sometimes we'll go out there on a Friday night and we have a barn fire, which we're upset because there's a fire ban in place for the last month, so we haven't been able to do that. But we also use that building for storage. Diane does, she's working on the antique mall up here. They're opening a whole new section, so we put furniture and stuff we store in there. So, I mean, if she wants to bulldoze that, it's hurting our livelihoods, for one. And I just don't understand why you have to remove a shed. I am going back out there to build another home. It's probably going to be our retirement place. I'm not going to sell this one like I've done in the past. And then the due process. How could I be served after I was supposed to correct the problem? I don't get it. I mean, so that's pretty much what I had to say. I don't know. Is there anything else?
Well, the architect, I went yesterday, and we had all these forms saying this. He said he could probably have it done in 2 weeks. We want to apply. I want my house. I want,
Yeah.
you know, we bought that
She
property.
loves the property.
The property value is only $48,000 because of those sheds on it, and we paid like $135,000 because it's so beautiful and we maintain it.
Well, then there's the other problem.
So
That we just found out they're building 1,750 homes in the backyard, which that was part of the beauty to the property. There's a 800-acre cow pasture, has cows and stuff on it. Well,
welcome to Florida.
They're building 1,750 homes there, which I'm kind of upset about, but oh well.
Sir, can the architects, you're more than welcome. They could call them. They're almost done, and as soon as they're done.
I don't know that it's relevant, and I'll talk to you a little bit about why. First of all, let me ask the county, is the county's case, I heard RV, boat, vehicles, is the shed a part of the county's case here?
So I discussed this with the county attorney and
That's
land development.
I'm sorry, sir. Could
The
you
land
answer?
development director yesterday. There was the unsafe back in 2019, 2020, and the code officer, the previous owner had removed the mobile home that was on there, and that case abated with like a shed or a barn that was on the one shed or barn that was on the property.
No.
Excuse me, sir. No.
Oh, okay.
Since then, if you look at the aerial photographs, additions have been made to that original structure, and then of course all the accumulation of the boats, the vehicles, the RV,
All right,
the pool.
so the vehicles, RV, that's easy, all right?
Yes.
Clearly a violation.
The pool is like a little.
The pool is also a
hot bubble
violation.
one.
But here's what unless it's permitted, so here's what I want to get at. He talked about permitted structures. What in your case has been permitted that you actually think is a violation here?
It's the
Nothing.
Nothing.
Okay.
Oh, no, nothing
permitted.
permitted. I'm
That-
sorry.
that's what I wanted
I'm sorry.
to-
I was trying to refer to the extensions
Because I agree.
that have been made
I really
unpermitted.
don't think I can compel the removal
Bless
of
you.
something, bless you, that has been appropriately permitted.
Right.
Okay, so we're on the same page about that. Now, did you hear anything you disagreed with from Mr. Nielsen that you heard?
No.
Okay.
I don't really
I-
disagree with anything, but
Other than the fact that he claims there are 3 sheds or something on the
I'm
property.
not-
Yes, there are.
Guys, this is the
Aye,
last time
sorry.
I'm going to say it. Thank you.
Yes, sir.
We can only ascertain that there was 1 shed on the property, and it appears that the footprint of that shed has grown since the demolition occurred. So at this time, the county is only agreeing that there is 1 shed with a smaller footprint that can remain on the property without the appropriate
And
development
that's
order.
the shed that was permitted.
Correct. It's allowed on there.
Now, we'll get to you guys. I want to hear what you have to say. I just want to make sure we're all on the same page about what's at issue. So specifically, Ms. Olson, what are the violations that I need to address with them?
So everything except the original footprint of that shed
So,
on a vacant property.
so anything that's on there that, and so you're saying there's only one permitted structure on the property?
Yes.
Which is the original footprint shed?
Yes.
Okay.
That
All right.
I can see.
That you can see.
All right, let's go to you
My
guys.
turn? Okay, the size on the building permit website of the permits of the sheds that were added, those sizes are the same size for the sheds that are out there. That's what, a coincidence? No. There's 3 structures out there. They're on the aerials. They've been on the aerials since I've gone way, way back on all the aerials I've seen, because those things were permitted in 1980 and 1985. There's not one shed out there. There's always been 3 sheds. And yes, if you look at the aerials, you can see them. And then there's
So
also...
I'm looking, let's get on the same page. So
All
I'm
right.
looking at an aerial from, this is page 14, I think, of Exhibit A. All right, so I'm going to show it to you as best I can. This one would be a shed, right? This is, I think,
Can
was
we
this?
come closer? I can't.
Yeah, why don't you all come
Go
up
ahead,
and
Joe.
point, and
You want me to
county
take
can
it?
come too. Let's have a confab here. Show me where the sheds are.
That's the one that was there when we bought it.
I'm sorry, which is the one?
That's the like a little shed.
That's the one permitted, that we all agree?
All 3 of them.
One of them. 1,
Okay.
2, 3.
This
Right.
Okay, this one,
And
this one,
And there's another white one right there.
there's
That's
one in
just a
there.
little put together one.
Okay.
We don't care.
And you believe that all 3 have been permitted?
Yeah.
And you gave me dates? Okay.
Yeah,
Now,
because
it's the
if you look
county's
at the
position,
sizes
excuse
of
me,
that-
it's, how many, did you see where they put the 3 shed locations?
No, I can't.
Okay. Where is your understanding, you said there's only one. Where do you think the one
From
is?
the road, I can really only see the roof
Okay.
of this one.
Okay. Okay, that's fine. So we are on the same page. You're saying there's 3, you're saying there's 1. Okay.
And then, if you look at the billing, now, everything is the way it was when I bought it out there. I just bought it in May, so we haven't added to anything. I've just been making the property look better by picking up dead branches and mowing the
All right,
lawn and, manicuring it and stuff.
Let me take some time to explain this code section. So Code Section 3102A is basically saying that until you've established your primary use, which will be a residence, which
Right.
you say you want to do,
Right.
you can't have accessory uses, which includes storage, which includes placing vehicles on there, which includes having a pool. Does that make sense?
Oh, yes, it does, but I want to go back to the actual summons that I received, or whatever you want to call it, the
I
notice of
don't.
violation.
I don't. So
It says that.
I don't,
it
Mr.
says that
Nielsen.
my
Mr. Nielsen, do you
structures are
hear
the
me?
problem.
Can you hear me?
Yes.
Oh, okay. So no, I don't want to talk about that right now. What I want to talk about is, you had mentioned the code section, and, does that code section make sense to you?
That you're not allowed to have another structure?
Accessory uses or structures until the established primary use, meaning your house. Does that make sense?
So how do you maintain your property without having things to do that with?
Well, let me give you an example. So we've had cases where, by the way, we have the county attorney here in person right now. So we've got, I don't know, don't you have like a succession plan? What if something happens in the courthouse?
Sally controls everything.
We've been watching.
Okay. Well, then here's the issue. We've had cases before where there's a 1/4 acre, where there's half an acre. There's no permit to put the primary residence in there. So that's a problem if you put a bench there. You can't have a picnic bench there because that's an accessory use. A shed, you brought up sheds. Unless it's permitted. We can talk about something that's been permitted before, but you can't just put a shed on a piece of vacant property.
Wait.
Does that make sense?
Yeah, but if it was permitted, they're permitted.
So we'll get to that, but unpermitted. Let's just say
There's
unpermitted.
nothing there that's not been permitted.
Well, I see on the photos what looks to be an RV.
Well, that's all gone. There's nothing there
Okay.
right now. Those people moved out.
Okay. I see a pool. Is the pool
The
still
pool
there?
is there. We've been swimming. It's a little blow-up kind of pool.
That's a
Just little-
violation. So what else?
It's so ridiculous you can't have a pool on your property. I don't get it.
Well, you can, but you've got to build something there. let me ask the
Okay,
county.
well, I should have a permit to build
Sir, this is the
in
last
a little
time,
bit.
the last, I don't want to be disrespectful. I try to go out of my way to let you be heard. I'm only willing to be interrupted 4 times. You've got the 4 strikes, all right? Does this make sense that I don't want to be interrupted anymore?
I thought we were
Yes
having a
or no? Does it make
I
sense?
thought we were having a conversation, just like you just
All
asked
right,
me
we've
something.
got a problem. So, what is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master order the removal of all items from the property, including vehicles, boats, RVs, and other miscellaneous items, and further order that all unpermitted additions to the barn be removed, with only original permitted barn allowed to remain. We also request to be allowed onto the property to ensure compliance. The division further respectfully requests that the special master assess a fine of $350 per day, along with applicable administrative costs, beginning on the date that you deem sufficient by the special master to allow for the abatement of the violation.
Okay. So, is there anyone from the public who wants to be heard on this case? I don't see anyone. So what I'm going to do is, let me ask the county one more question. How much, if they obtain a permit for the primary structure, does that abate the violation? Like just receiving the permit?
I mean, they would need permits for the other sheds or
To keep it
barns
there.
to keep them there, yes.
And just receiving a permit to build the primary structure doesn't allow
Right.
keeping the pool per se?
Right.
It would have to be completed?
Right.
Okay. All right, then what I'm going to do is I'm going to grant 60 days to bring the property into compliance. And what is the recommended?
$350 a day.
If it's not brought into compliance within 60 days, $350 a day. Okay?
Thank you.
Okay, let me go back. I don't understand what she wants for compliance. If the buildings that were there were permitted, I can't have them there, even though they were
So
permitted?
you're allowed to have the permitted footprint. You are not allowed to have the unpermitted footprint. Anything that wasn't permitted, any other accessory use has to be removed.
And if,
And I'll issue a written order.
so in 2 weeks, when we apply for our
Building permit.
building permit, I mean, I don't understand.
That doesn't abate the accessory use issues. And I will issue a written order that will make it clear. Thank you.
Thank you.
So it's the county's position where you're gonna just hurt me?
Sir, the case is over. The case is over.
You know,
You've got 60 days to comply.
I guess I'll
I don't
appeal
want to
it.
reduce it,
I
but
will
swear.
appeal it.
Your
But here I'm
ability
served
and willingness
after I
to
was supposed to
cooperate with the
comply.
county
How
will
is
be
this
an
due
issue.
process?
You don't get to
That's
just
not due
do whatever you
process.
want, whenever you want. And let's talk about that. You've now had 65 days, actually over 60 days since you were served with it. Nothing's been done. Instead, you came here and argue about obvious stuff, that a code section that everyone else understands. You can't build 1,500 houses, manufacturer or not, come here and not be able to read a simple code section. That's enough, sir. Thank you.
Next case on the day's agenda, Unique Homes LLC, case number 2025-1928, Code Officer Erica Olson, page 33 of your agenda.
And you get to follow that.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name, sir.
My real name is Marin Daniel Weeks. I go by Dan.
Thank you.
And my hearing aid battery went dead sitting here, so I want to.
Do you hear me okay?
I can hear you, yeah.
Okay. Good afternoon.
Afternoon. This is a repeat violation initially observed on the 23rd of October. The address of the violation is 6049 West Green Acres Street, case number CE 202501928. The violation is accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, Tech 31 Alpha of the Citrus County Code of Ordinances. The property owner, Unique Homes LLC, has been previously found guilty of the same violation at this same location on the 15th of January 2025 under case number CE 2024-01972 with $0 in imposed fines. That case was abated on the 6th of March 2025. Good service was achieved via posting on the property and posting at the Lecanto Government Building. I respectfully request to authenticate the following documents and have them admitted into evidence. Exhibit A, the findings of fact and order acknowledging compliance from the prior case. Exhibit B, photographs taken during my initial inspection on the 23rd of October 2025, subsequent inspections on the 10th of November and 20th of November 2025, and the final inspection on the 15th of December 2025. Exhibit C, a copy of the notice of violation, a copy of the notice of hearing, the posting affidavit, and a photo of the NOH, NOV posted on the property, and a copy of the SunViz.
All right. Can you please take a look at the documents that she's just talked about and let me know if you have any objection to them being evidence?
That's just from the previous case. And then this is the paperwork from this case and the photographs.
No, I mean, I've seen the pictures for it.
Okay, all right, then I don't hear any objection. What's been proposed as Exhibits A, B, and C will be admitted as evidence. And let me just take a quick look.
Okay.
I do remember the prior case.
Mm-hmm. It was bad. Inside.
Yeah. Let me just take a look at the photos. Okay.
Speak now or?
Not quite yet, thank you.
I conducted my initial inspection on the 23rd of October 2025 and found the property to be in violation due to overflowing trash along the roadway, a workbench by the garage that had clothing and other items stacked on it, and the garbage bags and cinder blocks near the garage. The property was posted with an NOV, NOH for the hearing. On the 10th of November 2025, I conducted a follow-up inspection and found the property to be in compliance. On the 20th of November 2025, I conducted another follow-up inspection and found the property to be to be in violation. As of my final inspection on the 15th of, in compliance. As of my final inspection on the 15th of December 2025, the property was observed to be in compliance.
Okay.
I'm sorry.
Now I would like to hear from you.
Okay, the first case, the people had to evict them, and it took me several months to get them out of the house. And Ms. Olson seen the house. Whenever I got them out, the house was just totally trashed. I mean, trash. We ended up hauling 4 dumpsters of trash out of there, 3 pickup loads. There was 30 cats in there. There was 5 deceased cats in the house. There was no way I could have anybody even go in that house and clean it. I have a guy that works for my son. He's a disabled vet, a younger fella. He works 6 days a week. I let him move in there free, and he's been cleaning it up, and he has done a lot of work in there. From the pictures, my father was, he just died this month. We just buried him last week, but I was in Jacksonville all during October and November, so I wasn't around the house. But when they got my wife called me and got the letter from Miss Olson, I sent my son out there. And when he went out there, he said, well, there's no trash in the yard. I guess the 2 trash cans were gone. He said there's a few chairs up by the house. And so I immediately drove back to Citrus County, and I called Miss Olson on the 30th, and they told me she wouldn't be back to work till the 10th of November. She was in classes or?
Yes, sir.
Yeah. And so I talked to the lady on the phone. I said, well, what is the problem? She said, well, the 2 trash cans by the road doesn't have a lid on them. I didn't know you had to have a lid on them. I mean, everybody in Citrus County sets the trash cans out. It was inside this fence by the road. The only other thing she mentioned was the tree limbs in the burn pile. Said that they was in violation, and I didn't know. I mean, I thought we've been burning. I've lived here all my life, and we've always been burning pine tree limbs. They fall all the time. And then she mentioned there was a refrigerator on the enclosed porch, or appliance, but it wasn't an appliance. It was a cabinet that was inside, which I didn't realize was a violation to be on an enclosed porch either. So I told Mr. Croker, move that out of there, get rid of all the limbs, and the trash is already gone in the 2 cans. He put it out there so somebody could pick them up.
I mean, the whole point is that it's, whether it's enclosed or if you can see it through a screen and, it's a nuisance.
It was a cabinet. It's gone now.
Yeah.
I've had Mr. Croker send me, while I was still in Jacksonville taking care of my father, I had him send me pictures of the front yard at least once a week, twice a week. I have him on my phone to make sure he's understanding it's going to be clean, because I know he has a neighbor across the street he got in an argument with, and I told him, I said, if you leave a bottle cap in the yard, they're going to call on you. And of course, when she comes out, it's her job to, look for any kind of violation.
Ms. Olson, have you seen improvement as the case has gone on?
Yes, sir. And when I first got this violation, I did call Mr. Weeks and let him know because I knew that he rented the property out. He has always been more than open to, fixing whatever needed to be fixed. He's always very nice. So it took a little bit initially. My notes here say 18 days just to get everything that I needed done.
Well, so what is the county recommending on this case?
So due to it being a repeat violation, Code Compliance Division respectfully requests that the Special Master assess a fine of $150 per day along with administrative costs to begin on the date of the posting on the property, the 23rd of October, and continue until the 10th of November. 18 days and $150 a day, totaling $2,700.
And I'm sorry. Oh, is it in compliance now?
Yes, sir.
Oh, it is?
Yes,
Okay.
sir.
Okay.
It came into compliance like right after that 18 days. And
I'm sorry.
my-
Okay,
my
I was
subsequent-
kind of wondering what the 18 days meant. Okay.
Yep.
That makes sense. Is there anyone from the public who wants to be heard on this case? Okay, well, there's no way out of it, sir. I mean, well, yeah, I'll let you take, but, on a repeat violation, normally the county does ask for $350, $250. I mean, even just to say $150 is the county being Christmas spirity, but I do want to hear from you.
For me?
Yeah.
Oh, okay, I didn't want to interrupt.
Yeah,
I'm sorry.
I'm sorry, you had to see that last.
I did come back on the 29th from Jacksonville. I did call Ms. Olson, which is not her fault, she wasn't in. I did try to get someone to come out there to inspect it that day, and they said she wouldn't be back till the 10th. So, I mean, that's 11 or 12 days that I had no control of. I mean, we had it cleaned, but I had no one that could come out and inspect it.
What does the county say to that?
And that's fair. I mean,
it sounds like
I understand where he's coming from.
It sounds like that's the evidence that I have. In other words, that I don't know that it was still in violation beyond that date.
I do have pictures. He texted me.
I don't know that it's controversial.
Okay.
But how if that's true, then how many days was it in violation? 8?
You said the 29th, sir? Yeah.
But I didn't receive the letter in the mail till the 29th. I mean,
that doesn't count,
7 days.
Okay. So that'd be 1,050. I mean, look, I think in lieu of the fact that you said the working relationship is working, they tried to fix it as soon as they could.
Does.
The point is compliance, but I mean, the next time it happens, it's
not
going to be a
gonna-
250
it's not
or
gonna be
350.
the
I
next-
don't know what the county will recommend.
Yeah, I'm actually, this guy living in the house now, my son's supposed to be getting him a place in March, and he'll be moving out. I'm a general contractor. I'm going in there remodeling the house and selling it. I don't want to be putting up with this no more.
Okay, well, I'll find that it is a violation, it is a repeat violation. I think exhibits A, B, C are in evidence. It'll be a fine of $150 a day for 7 days that it was out of compliance. There you go.
Okay, but what is the, just the 2 trash cans sitting in the front yard, that's
Well, you can't
sitting by the
have
road?
unenclosed litter receptacles, that's in the code section, so.
It'd be most of Citrus County.
For more than 24 or 48 hours, there's a time period, so 3 days, it can't just sit there.
And they were very full.
Yeah.
Yeah, they were very full.
They were very full.
They were very full, but he had someone picking them up the next day, I guess, or.
All right, so the hearing's over, and what I'd like to do is take a 10-minute recess. The time is 12:19. We'll be back at 12:30. Thank you. The time is 12:31. This hearing is back in session, whether people are ready, I guess, or not. So where were we?
We can
Let's
pick
take
back
up Mr. Shahid. All right, so this is, if I recall, let's put it on the record, case number 25-1785. I have had a time to think about it, and I see it as two issues, one that I'm going to rule on and one that I'm not. So the issue I'm not going to rule on one way or the other is the leaves. I am going to rule on the trees in the concrete crater. I do find that that's a violation of the code section, and the reason is in prior cases, I have held that things like saplings that grow above the limit are violations of this code section. In order to be consistent, I have to find, whether anyone likes it or not, that is a violation. So what is the county's recommendation on this case? $100 a day. Okay. Mr. Shahid, I'm going to give you 30 days to bring the property into compliance. It would be awesome, by the way, if you took one garbage bag or two garbage bags and put the leaves in the garbage bags, by the way. That would be so wonderful for your neighbors in the county. But 30 days, if it's not brought into compliance as ordered, $250 a day, and I appreciate you being here.
No problem.
Thank you.
Thank you.
Okay, and let me think, is there any other case that we have folks here for?
Yes,
Well, no, I know, and I'm not trying to avoid.
There's no other.
Okay, there's no others. Then let's do it. Let me make a decision then. Okay.
Next case, Deer Trust.
Okay. Well, you know the phrase that no good deed goes unpunished. Do you know that phrase? You don't?
I'm not familiar with it.
Well, it is a phrase in English. And, I take it as accepted. I take it as a given that, you had these two other code cases, you brought it into compliance, and you did what you had to do. The narrative, the facts of what I gather from both sides and how it comes out is I actually think you both have testified pretty consistently. I know you guys might both disagree with that, but from my perspective, it's pretty consistent, which is, and I think the answer to Ms. Harrison's question is probably dispositive in this case. In other words, there was an important question that she asked that I think leads me to the result in this case, which is that, you worked with Mr. Crabtree to fix these other properties. You did the good deed. Of course, it never should have been out of compliance in the first place, but you brought it into compliance, which is expected of everyone. But in so doing, you did make a material change on this property. I know how you feel. Look, but that is going to be my finding. I think it is pretty clear. I can't get around the fact of what I see in the evidence, what I see from the testimony, which is that there is a change there. It's not a coincidence that it's where a pad would end up being, even though I agree it's not the complete size of a pad. I'm just listing out the reasons for the record. You can appeal me, of course, if you wish. So I do think that Mr. Jonason's observations are correct. I think that Mr. Crabtree's testimony is correct. I think your answer to Ms. Harrison really explained the whole situation. And therefore, I will find that there's a violation. I'm going to assess a $2,500 fine, and that's my ruling.
Thank you.
Good luck.
All right. Next case, Walter and Michelle Bevington, case number 2025-1846, Code Officer Julie Wilkerson, page 7 of your agenda.
You want the narrative or the whole shebang?
Narrative.
Okay, so this is a case involving junkyard conditions. The property, it's a residential property with a lot of junk. He has made progress, but it's not quite there yet.
You've had contact with the owner?
Yes.
And, I mean, on the scale, give me a scale reading.
Well, it started at like a 7 or an 8, and right now the front is probably about a 3. And what I can tell from the back and the side, it's probably like a 5 or so.
Let me
yeah.
see the photos
Yes,
then,
sir.
and we'll see how much time they need. Mr. Tron? Oh, okay. Do you have to show my face? Gosh. It's unfortunate. Sorry, viewers. No problem. I can survive without paper clips. All right, so exhibits A and B are admitted as evidence without objection. And what is the county's recommendation?
Because he has been making progress, I'm recommending $50 a day.
Okay, now this case is 2 months old,
Mm-hmm.
and it's still not great, right? So,
Yeah.
all right, I'm gonna give 30 days, and it's gonna be $50 a day.
Okay.
Okay?
Thank you.
Next case, Trevor McKenzie, case number 2025-674, Code Officer Cody McGuire, page 25 of your agenda, expert on the case, Land Development Director Joanna Coutu.
What's that? Yeah, not yet. I do.
Okay. Good afternoon.
Good afternoon. Cody McGuire, Citrus County Code Compliance Officer, case number 202500674, a violation of Citrus County Land Development Code, section 4002, site development without a development order or permit. The address is 434 South Little John Avenue in Inverness, Florida. It is 0.96 acres and it is zoned CLR. The property owner is Trevor McKenzie. And then I have good service via posting the notice of hearing the property and at the Canto Government Building.
And just tell me what's going on the property.
Yes, sir. So nuts and bolts is Mr. McKenzie had brought in some fill dirt and spread it on his property without a permit. I've only talked to him one time. He told me that he was trying to do a unity of title for the 2 properties. I haven't seen anything in there stating that he has done that, and I've lost all communication with him.
When did you initially open the case?
This was on September 3rd of 25.
Let's go ahead and admit the exhibits just to make sure there's a record. And what is your recommendation?
A one-time fine of $2,500.
Okay, and for the record, that was a one-time fine of $2,500. I'm looking through the photos. Exhibits A and B are admitted. The property is in violation. A one-time fine of $2,500 is assessed.
Thank you.
Yep.
Officer Erica Olson, page 8 of your agenda.
This is case number CE 202501985, 6674 West Renee Lane. The summary is that they pile their household garbage up on the side of their house. They put it in children's toys and they pile it up at the front of their house. There was a previous case on this that abated before it ever went to hearing, and they're doing the same thing again.
You've had contact with the owner?
Not since the first case when she called to ask for an inspection to abate.
Let's get the exhibits admitted at least, and then tell me what your recommendation is. Thank you.
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $250 a day along with administrative costs.
10 days, $350 a day.
Thank you.
Next case, Ralph Bosley III, case number 2025-1836, Code Officer Cody McGuire, page 9 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 2025-1836. Address is 1469 West Lyrical Lane, Christopher, Florida, .31 acres, and it's zoned MDR-MH, and the property owner is Ralph Bosley III. This is just a junkyard condition case. When I spoke to Mr. Bosley, he just said he needed a little bit more time.
How much time did he tell you?
Not much. I would think 2 weeks would definitely be enough.
Can we admit the exhibits and tell me what your recommendation is?
This
Just
one's
the
gonna
amount. Just the amount.
Just $100 a day.
$100. Yeah.
Sorry, quickly, not to interrupt. The address you put on record was 1469. Is this 8469? Is that an error?
8469.
Okay, thank you.
Thanks. All right, so exhibits A and B are admitted as evidence, and he said 2 weeks?
Mm-hmm. I think 2 weeks. He said that it would have been done the other day, but I wasn't able to go back out.
7 days. But, all right, I mean, have you had a good relationship? Has he improved the property?
Yes, sir.
Okay, 14 days, $100 a day.
Thank you.
Yep.
Next case, Matthew and Cody Boyd, case number 2025-1880, Code Officer Julie Wilkinson, page 10 of your agenda.
This is another junk case on a residential property. I have had contact with a female occupant. She has removed one item, which is a bed frame or a headboard and all that, but there still remains some loose trash, a piece of wood, and
What is it on the Amy
coolers.
Becker scale?
A 1.
A 1? Really?
Or a 2.
Oh, okay. Then can I see the photos and, all right. Exhibits A and B are admitted as evidence. Oh, it's not a 1.
No?
No.
Oh, okay. I'm jaded, I guess.
Yeah. I mean, if there was an old baseball sitting in the grass, that could have been, let's see.
Yeah, that's right, not my scale.
That's right.
Amy's scale.
That's the key. All right, and I'm sorry, what was your recommendation?
Excuse me, about $50 a day.
Okay. Then we'll do 7 days and $50 a day.
Thank you.
Thank you.
Next two cases, Sylvia Lopez Castaneda, case number 2025-1862 and 2025-1863, Code Officer Cody McGuire, pages 11 and 12 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 2025-1862 is accumulation of junk and debris, and then case number 2025-1863 is excessive growth and accumulation. I haven't had any contact with this property owner or anything. She's got some discarded furniture in the back, and the front's overgrown as well.
Okay. Back to our meat and potatoes cases. What is your recommendation?
I haven't had any contact, so I don't know. My best guess would be another 30 days, and then hopefully that would do something.
Can I see the photos?
Sure.
All right, exhibits A and B are admitted as evidence without objection.
$100 per violation.
Well, you started this case 2 months ago. I mean, when did you notice it?
Well, the first time I was out there was October 15th.
So that's when they, I mean, did you post it? Did you serve notice? When did that happen?
The notice went out after that when I got back.
All right, I'll do 14 days on each case, and if it's not brought into compliance, $100 a day.
Thank you.
Thanks.
Next two cases, Dana Harbison, case number 2025-1850 and 2025-1851, Code Officer Erica Olson, page 21 and 22 of your agenda.
Case number CE 2025018850, accumulation of junk and debris. And case number 2025018851, excessive growth and accumulation of vegetation. So initially when I went out, there was just like some garbage, and then in the back there's like this pile that has a mattress in there and a bunch of other items that I can't really make out, and then the remnants of what I think was an RV. The front yard is mowed and seems to be maintained. It's the backyard that has some growth next to the pile of junk.
Okay. Can I see the photos? And
Yes, sir.
You can let me know your recommendation. Exhibits A and B in each case are admitted as evidence.
So for each case, I recommend $100 a day with administrative costs.
Did you miss this, Miss Antrim? Sparrows, do you think you're going to miss it? Okay. Oh, a viewer, okay. That's always exciting. All right, so in case number, let's see, 25-1850, the junkyard conditions. Okay, you said $100 a day?
Yes, sir.
Okay, 30 days, $100 a day. On case number 25-1851, 14 days, $100 a day.
Thank you.
Yep.
Next two cases, we're prepared to run them together, just different addresses, but same owners. You okay with that?
Very.
Okay. Edward Scott Hallweg, case number 2025-1953 and 2025-1954. Code Officer Julie Wilkinson, page 23 and 24 of your agenda.
So they're both going to be lawn cases. Case number 1953 is at address 100 South DeSoto Street in Beverly Hills. And case 1954 is at address 102 South DeSoto Street, Beverly Hills. They both had started out with overgrown grass and accumulation of vegetation. At 102 South DeSoto Street, they cut the grass, but the tree debris remains. At 100 South DeSoto Street, nothing's been done.
Are there prior cases? Yeah.
Yes,
okay.
we have previous junk cases.
On these lots or on different lots?
On 100 South DeSoto,
Okay,
that's
I
getting daily
recognize
fines.
the case. All right. Well then, let's take a look at the photos, and we'll admit exhibits A and B in each case, I believe, without objection. Thank you. In case number 25-1953, the overgrown, unkempt lawn. But, I mean, did he abate the prior case?
No, it's still getting daily fines.
Oh, okay.
Mm-hmm.
And I'm sorry, did you say you had contact with the owner?
I've never had contact with this person.
All right, well then, in case number 25-1953, 10 days, $300 a day. In case number 25-1954, 10 days, $350 a day.
Thank you.
Next case, Stacy McCord, case number 2025-1888. Code Officer Erica Olson, page 26 of your agenda.
Is there only one more case after this? Okay.
Case number CE 2025-018888, 1215 South Gettysburg Drive. This is for excessive growth and accumulation of vegetation. I have not had any contact with this person, and it's very clearly
Okay.
overgrown.
Then, if you would, exhibits A and B are admitted as evidence. What is the county's recommendation?
$100 a day plus administrative costs.
Yeesh. It's like they're growing wheat back there or something. But it's not wheat.
Just weeds.
Yeah, I don't know. Yeah. I mean, you know, it might be Florida friendly, though.
I don't want to hear this.
I don't know. All right, then I will do 10 days. And what was your recommendation?
100 a day, sir.
100 a day.
Thank you.
Thanks.
Last case, Carl Jeffrey Neild and Rhonda M. Walsh, case number 2025-1937, Code Officer Alan Jonason, page 27 of your agenda.
This is a repeat violation observed on 27 October 2025. The address is 2990 East Blackberry Lane, Hernando, Florida. Case number 202501937, accumulation of junk and debris. Do you want me to go through the rest of this or let you know what the fine is?
What was the prior case?
So the prior case was a junk case, and you heard that it abated on 7 December 2023.
Okay. And did it abate with any no fines?
So it
or-
did abate with fines. The fines were forgiven, but there's they paid $306.42 in fines.
When the fines are forgiven, do they ask code? Who do they come to ask?
Lori Spiros.
Lori,
Uh-oh.
they requested of Lori its process, but it's ultimately the county administrator who makes the determination that,
Okay.
and they're forgiven, but they still have to pay administrative costs and hard costs to the county.
Makes
So there
sense.
is still a nominal fee. Unfortunately, for this individual, you can't get forgiveness for a repeat violation.
Well, I'll tell you, I mean, I've always said don't get on Lori Spiros' bad side because if
I
you.
say that too.
All right, then what's going on the property?
Okay, so I was out there on the 27th October. Subsequent inspections on 10 and 25 November 2025, 3 and 9 December 2025, and photos from my final inspection on 16 December. It did abate yesterday. It was abated yesterday. So we request the special master assess a fine of $200 per day along with the administrative cost to begin on the date of the posting of the repeat violation notice on the property, which was on 6 November 2025, and continue until 16 December 2025. That's 41 days at $200 per day, totaling $8,200, plus administrative
Let's
costs.
get the exhibits in the record.
Sure.
Exhibits, I assume A, B, and C are admitted without objection. Have you had contact with the owner?
Every time I was out there, I spoke with them. I informed them that they were assessing a daily fine, and they understood.
Okay, then I will follow your recommendation. The property is in violation. It's a repeat. There will be a fine assessed of $200 a day from November 6th to yesterday.
Thank you.
And I think that's it. Now, that completes the cases. Is there anything else that anyone wants to bring up?
If we could just formally say goodbye to Ms. Spiros. This is her last meeting with us. She will no longer be with the county.
All right, so Ms. Spiros, is there anything you'd like to say for yourself?
It has been an absolute pleasure. It truly has. And everybody will be missed, and that's it, because I don't want to cry.
Well, I think it's well-deserved, and so I've had the opportunity to be a special master, the main special master, since I think March of 2021. And in the 4 years prior to that, I was the alternate, but had several hearings that I got to attend. And, you know, you came on right after I became an alternate special master, like a month or two after. And I just want to say it's been a pleasure working with you, and thank you for your service and always picking up the phone and not laughing at me too much, which I appreciate, and good luck and warp speed. Okay. Is there anything else that y'all have? Time is 12:56. This hearing's adjourned.